Maybe for to mention on that.
Today is not the mentioning, they mention on Monday.
And for the petitioner.
Who is appearing for respondent number 3? Who is for respondent number 4?
My lord, I am for the respondent number 4, your lord.
And 3?
Oh, 3. My lord, I am for 3. I am for 3.
Director National Test House, who is appearing? You are appearing for Director National Test House. 1, 2 and 5. 4 and 5. There is an added respondent. You have not supplied the amended cost title.
No,
Yes.
not yet.
What is
Yes, send it.
No, you have
amended cost title of the writ petition?
They were present.
No, he was not present on the last
No,
occasion.
he was not present because he was.
So why you have not served the amended cost title? You have to serve.
I think I have said. I have not.
Show me that you have served the amended cost title.
I have not brought that slip, postal slip. But I.
Show me you have served the amended cost title.
No, I cannot say at the moment.
Because Director National Test House, on your submission, I have permitted you to amend the cost title, and then this notice was served. Notice has to accompany the amended writ
No.
petition, indicating additional or added respondent, indicating additional respondent. Where is such notice? He has to obtain instruction from director, because he is the since he was not represented, that's why matter could not be heard. Have you obtained any instruction from the Director National Test House? Yes. Place your case.
My lord, there is a case that I have come here challenging the order of the CGIT.
Order of
CGIT, Central Government Industrial Tribunal, wherein they have dismissed my
central government. Where is that order?
page number 29 onwards.
Where is the illegality in this order?
The tribunal has considered that since he is an individual employee, workman, so there cannot be an industrial dispute.
Yes, because a contract is between the principal employer and the
coming.
immediate employer.
I am coming to that. That's not that. It is not the fact. Kindly, in that case, kindly come to the page 31, second line.
Does it not come under section 200 of the Industrial Dispute Act 1947?
It comes as 2A.
Yes, it has been observed by the tribunal that it would be suffice to say that the termination of workman is not covered by the provisions of section 200 of the Act of 1947, where termination of service of workman as a result of non-renewal of contract contract of employment has been given an exception to the definition of retrenchment.
I'm coming to the point. That is
Now, what interim order you are asking for?
reinstatement at the moment.
So that is the final order. So it has to be on the.
Reinstatement with back wages is the final
That is
order.
the final order.
Without back wages, I continue.
There will be a filing of affidavits first.
That's it.
Since all the parties are present, court had to pass several orders since respondent. Yes, you are the who is the principal employer?
National
My lord,
You are the security agency.
yes,
So you are the immediate employer, and the principal employer is the national test agency.
yes.
Interestingly, my lord, the security agent, they have not appeared before the CEIT, not submitted any WS.
Who?
And yes, security.
Security agency.
Yes.
Immediate employer.
Any employer. My another submission is kindly go through the page number.
Very well. Today there is no scope. File your affidavits, come back. It's an assigned matter.
Yes, assigned matter.
So then this court has to hear this matter. Which authority did not appear before the tribunal?
My lord, I did not appear.
And not even
Security agency did not.
No.
Why?
That I have to take instructions. I was not there at that point of time. So
kindly see
no,
page.
only the thing that I can say here, my lord, is that, my lord, the petitioner before your
But
lordship is
24 June 2020 order.
No, 20.
yes,
Page
24 June
34.
2020 order.
Come to page 34.
Huh.
24 June 2020 order. You have challenged in 2024
Because he was suffering.
after 4 years.
I'm telling you, submitting. He was suffering from cancer patient, so he was busy on that test. Thereafter, he approached the High Court Legal Committee. So they considered it, and they ultimately appointed me, and I got it after some time.
No pleadings made.
Till he's a cancer patient.
No pleadings made.
Have you given this explanation that the petitioner was a cancer patient?
I think so. Let me
Show me.
Oh, first of all, he went to the State Labour Commissioner. Therefrom, it has come. No, it is not. No, that's not.
There is no pleading.
No.
Where is the explanation of delay?
Kindly.
My lord, kindly come to page
Kindly
para 22.
Page
Is his
25.
petition.
Right.
Page 25.
Uh,
No, in the
No, no.
body of the petition, where is the explanation?
Huh?
In the body of the writ petition, where is the explanation?
I'm
In
ready.
the in the pleadings, where in which paragraph you have given the explanation of delay?
Page 27. Page 27. Sorry, paragraph 27. Sorry, I'm extremely sorry. Page 6, para 27.
The cancer কত কোথায় লিখেছে?
লিখিনি ঠিক আছে? Paragraph 30 also mentioned.
But where is the scope
Paragraph
of
30.
where is the scope of given relief to you by way of reinstatement after 4 years?
Because I was continuously with the authorities, and also I collected certain
This was a
information under
contract.
RTI.
This was a contract in between National Test House and the security agency.
No,
Now, this contract period is for a period from 1st of April 2002 to 30th September 2002. And the contract for providing service of armed guards had come to an end on 30th September 2002.
1/4/2003.
Come to page 34, paragraph 14.
Coming page 30.
Paragraph 14.
And
Apart from this, contract available on record shows that it was in existence between National Test House and Messrs Security and Investigation Bureau since 1st of April 2002 till 30th September 2002.
But page 31, their submission. So kindly see page 31. I was retrenched on 1st April 2003.
Yes.
Then how I was continuing when this contract
No,
was
now this contract is no more existing.
no more.
No more existing.
I was
Now this contract is no more existing. Contract came to an end on 30th September 2002. Then this
I was
order was
continuing.
passed by the Central Government Industrial Tribunal on 24 June 2020. In 2025, what is the scope of
Milord, first of all,
reinstatement
because first of all,
by setting aside retrenchment?
I'm saying, Milord,
When this security agency is not in the picture because the contract has been terminated or came to an end on 30th September 2002.
I was continuing till
Is it your case?
2003.
Is it your case that contract was a sham contract and
Yes,
you worked
yes.
there? Up to which date you worked there?
I worked there up to 1st April 2003.
Then
2002 to 2003, how I was engaged. Kindly see page 31. Page 31, third line. Their submission, not my submission. This is National Test House submission. I was retrenched on 1st April 2003. So October 2002, there was no contract with the contractors. Then how I was working between this period? Number one. Number two, this contract.
but this was not a period of for a considerable period of time.
But consider, yes, that means what I was
Up to which date you worked?
1st April 2003.
1st April 2003. It was beyond the period September, October, November, December, January, February, March for a period of 7 months.
Yes, sir. That means
Does
I
it
was
confer any
direct-
right
So I was, my submission was I was
in
direct.
absence of contract?
I was
I could understand that you were retained by the principal employer for a period of 5 years.
But the principal employer coming to know that there is a irregularity because this contract is also license holder. As per section 12, there should be license holder for supplying the employee. So they had no. I was RTI, I have annexed pages. RTI information is that they are
I
not.
will file exchange your affidavit. This one.
Milord, that's asked.
The writ
Milord,
petition. Anna. Yes.
Department of Consumer Affairs. Labor, Government of the Labor India, Institute of Consumer Affairs.
Where?
oh, he is telling.
The NTA, under the Department of Consumer Affairs.
National Test House, principal employer.
Department of Consumer Affairs, Union of India.
Which respondent?
Milord, one. He's talking about one.
One.
The service to the Secretary Department.
Under the Ministry of
Labor Department.
Here it is written Labor
Labor
Department.
Department, Government of West Bengal.
It would
No.
it would be Department of Consumer Affairs.
Yes.
Why?
Student public.
Why?
Under the National Test House.
No, National Test House has been subsequently made party. Presiding officer, Central Government Industrial. No, just a minute. National Test House, principal employer, 11/1 Judges Road. Then director has been added as party. No further amendment is required. Yes. You are representing director? Yes. In terms of the order dated 27 March 2025, department has served notice. And your director, in spite of several notices, why he did not appear? At least 3 orders I had to pass on several dates, and the advocate issued notice, and your director did not bother to be represented before this court. Ultimately, I had to give direction upon the department of this court to serve administrative notice. Then director will be represented. Unnecessarily wasting court's time. Is it the way? He's an illiterate person that is receiving notice from the court and he will not be represented. I could understand that an illiterate person has been made party. He doesn't know the consequence of the court's order. Several orders this court has to part unnecessarily for ensuring representation on behalf of the director. This is the conduct of the director. And then the registry had to issue notice, administrative notice, then director will be represented. This court will remember this conduct of your director. That I am not concerned whether he has come or not. I have not directed him to personally present before this court. কি বলছিলাম? Department has served administrative notice upon the additional respondent number 5. Stop. Now, additional respondent number 5 as it appears from the report dated 22nd April 2025 of Assistant Register 8. Stop. Let the report be kept with the record. Next paragraph. In the writ petition, order of the Central Government Industrial Tribunal dated 24 June 2020 is under challenge. The petitioner has prayed for reinstatement with back wages. Upon setting aside or this setting aside award dated 24 June 2020. Stop. Next paragraph. On perusal of the impugned order dated 24 on perusal of impugned award dated 24 June 2020, this court finds there is no scope for passing interim order. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks after ensuing summer vacation. Next paragraph. List the matter under the heading assigned hearing matter in the monthly combined list of June 2025.
One specific date.
Yes.
Specific
Yes.
date not possible. Specific date, month.
No. Hearing matter, let it come. Then
Only one
other
thing, my
matters are
lord,
also
your lordship directed, my lord, them to file the reply 2 weeks after the vacation. That will go to, my lord, July, because the court is reopening in the month of June. So monthly list,
just. Why?
3rd June. No.
my lord,
Monthly list of July.
yes,
But
deeply
Very
obliged.
specific date not possible.
Deeply obliged.
Yes.
Sir. Item number 2.
I am for the school respondent.
Malada, I appear on behalf of the petitioner. Malada is the pursuant to the notification.
of India led by Mr. Gautam Sardar.
Yes.
Malada, I have served.
By Mr. Gautam Sardar. He is on virtual. Union.
Yes, place your case.
So now Malada is the pursuant to the notification for admission of Malada class 6. The petitioner applied.
Who is appearing for the school authority?
Yes, I am happy.
CBSE.
Malada, pursuant to the notification, my son Malada applied for Malada the admission of class 6 under Malada OBC quota. So now this
Class 6.
class 6. Meaning the Johor Novodaya.
প্রাইমারি দিয়েছো কেন? প্রাইমারি ম্যাটার নয়, ক্লাস 6 এর অ্যাপয়েন্টমেন্ট, এই admission. Primary issue not.
My lord, it is my mistake, my lords. It may my mistake, my lords.
Yes, you have stated
Yes,
primary
yes,
education.
yes, my lord, I have, it is my mistake, my lord. Because of that, yesterday I take the leave from your lordship in my lord, in the Hari station, my lord. My lord, kindly excuse me, my lord.
Yes.
Now, my lord, this pursuant to the note, my lord, the application under my lord, the OBC quota. So now a admit card has been issued in favor of the my lord, the petitioners.
So you appeared in the admission test, you were selected.
Selected. Mal under
Under OBC
open
OBC
backward class.
A category.
Yes.
Under OBC A category, which is no more a valid category.
Because of that in view
Now,
of the
therefore,
my lord,
but your as you mentioned that you obtain the marks considering the same, if you are considered as a general category candidate,
then I can
then you will come within the zone of
consideration.
consideration for taking admission in class 6.
now Mal, I am
Yes.
showing. Kindly come to page 21. Out of 80 sheet, my serial number has come
Page 21.
21.
Yes.
Mal, this is the serial number 12. Jishan Rana Halda.
Yes.
So now this is under quota, open backward class quota seat. My lord, got it? My lord, this is the
Yes.
my lord, open backward. Now, my lord, is the then this this result has been published on 17th of March 2025.
Yes.
Then, my lords, total seat kindly last page. This is the result last page. Page 25. Total seat 80. There are
Page
7
29.
25. Last serial number 80.
Just a minute.
What percentage of master quota is?
So that is the rural scheduled type quota last. That is the serial number 80.
Yes.
Then my seat total seat is 80. Out of 80, I have been selected under serial number 12, open the backward class. Then my lords, your lordship kindly come to, then the school authority intimated me, page 27. Got it? 28. So now this, after publishing the result, after considering my candidature, the school authority directed to the comply the certain direction, certain document has to be submitted. Intimation regarding the provisional admission.
Just a minute.
Due to its undeserved obligation for girls and for boys. Right?
92.5
वो पढ़ नहीं तो थोड़ा जाने CBSE था CBSE তেমন লোক ছিল
girls 95, 96 and boys.
Yes. Then, my lord, it is very vital. My lord, this is a page 26. This is the central merit list which has been published by the central of CBSE, page 26, last cut of marks. That is the very vital. Now,
Yes. What is the last cut of marks? Tell me.
they have considered last cut of marks 86 for rural, urban.
Where from court will get it?
Kindly, there is the district court in 33, that is the state court. So now, my lord, if your lordships 1, 2, 3, 4, 5, 6, 7, 8. So now 86.25 rural boy under
Cut of marks.
lordships. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86.25. 86 my lord, it's
86.25.
25. Now,
Just a minute. Do not find it.
my lord, this the I can, my lord, this the
86 point rural unreserved.
unreserved.
86. What is the cutoff marks? Please tell me. That is important.
My lord, the
Indicate this.
my lord, the open category last cutoff marks 92.50. Here in my lord, under my lord, the general category 86.25. I got it, my lord.
Where is that?
My lord, this is the serial number, my lords. 1, 2, 3, 4, 5, 33. That is my lord. Here in my lord, I cannot. There is no serial number because of the I have annexed the relevant portion which has been downloaded from the my lord, the website.
Rural unreserved is 86.25.
Yes, my lords.
Rural unreserved.
Unreserved. Then here in my lord, open OBC last cutoff marks 92. I have been considered 92.5.
Open OBC. Where is that?
My lord, this the then my lord, the top my lord, kindly come to just my lord, the South Chobbish Pargana open OBC boy 92.50.
Boy, rural OBC.
No, open. My lord, this is the open. My lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 16, 17, 18, 19. The 20 serial, top two, the 20. Open.
Right hand side, right hand column.
Right.
Then rural OBC, then rural OBC, then rural scheduled caste, then rural scheduled caste. These are there. But where is open OBC?
Open OBC boy 92.5. That is my lord. I have this portion, my lord. 92.5.
Page 26.
26, right column, my lord.
92 point.
92.50.
That is rural urban.
No, my lord, open OBC, my lord, may I give in the
Then rural unreserved, rural OBC, all are rural.
all
Then
are rural.
open OBC, yes.
Oh, yes, my lord, 92.50. So I have been considered got 92.50, but rural unreserved that has been considered 86.25.
No, you appeared under which category?
My lord, OBC category.
Open OBC.
They have categorically, my lord, they have cited by lords, open, backward.
So you appeared under open OBC.
Open OBC.
Now you did not come within the zone of how much marks you have got.
My lord, it appears from since I have been selected under open OBC category.
What is your marks?
My lord, my statement is this 95%. Assuming that, my lord, I have
Whether petitioner has obtained 95?
He's confusing the issue. The question basic impasse that is crept in is the caste certificate. That has
What is the marks petitioner has obtained?
petitioner has qualified. Lordship will find petitioner has qualified and came within the zone of consideration within the 5 backward classes, other backward classes. Out of 5, the name of the petitioner is
What is the
figuring
marks petitioner has obtained?
marks
Please tell me.
that is maintained by the CBSE.
What is the marks petitioner has obtained?
Able to obtain that instruction because I got the petition yesterday and I said
That is the crux of the issue. What is the marks
The
petitioner has
crux of
obtained?
the issue is otherwise, my lord. The crux of the issue
No, I
is
quote wants to hear that what is the marks allotted to the petitioner.
no, that is your lordship's domain, my lord. I have nothing to add. But the question is, my lord, why his admission has been refused. That point, the question is only for caste certificate. That has been made nugatory by this honorable court. The question is not that how much he is within the zone of, he is within the 5, those who have been selected. Well, the question
But that OBC category is no more a valid
no,
category.
but that is the
If
only,
that is so, then why petitioner will not be considered as a general category?
no, where there is no such option because lordship will
Because
find.
this is a established, this is a trite law that suppose in an employment
Now I am
or in an admission,
I
if a candidate appears under scheduled caste category.
yes.
Now, if that candidate obtains
Yes.
marks that is above the cutoff marks under the general category,
No.
then why petitioner will
I-
not be treated as a general category?
I am answering this question, my lord. The question is, my lord, the petition, the cutoff mark
My specific
Yes.
query is
Yes,
this.
I have understood.
If petitioner is considered as a general category candidate,
Where is-
whether petitioner is coming within the zone of consideration or
no,
not.
no,
Why not?
because open unreserved for boys, the cutoff mark is 97.50.
Open unreserved for boys.
The cutoff mark is 97.50.
Where? 97.
Yes,
Yes, open unreserved boys. 97.50.
50.
Yes.
And this petitioner is not within the zone of consideration under unreserved category, but
Then-
in the reserved category, he is
In the
considered-
reserved category,
Yes.
you are submitting that he appeared under OBC A category.
Yes.
Now,
But-
OBC A category, whether you are considering OBC A category now in view of the judgment of the Honorable Division Bench.
Yes, that is the only issue in between.
So, how many candidates appeared under OBC A category?
Under these details, whatever details that is
Just a minute.
that is going.
How many candidates appeared under OBC A category?
Yes, to the Prabhupada. তাদেরকে করবো সেটা দেখবো না। কতজন ক্যান্ডিডেট ওবিসিতে appear
And why petitioner's name is appearing under the category open backward class quota seats?
open backward, because your lordship will find from the form that he filled up during, he claimed himself in the open backward category.
Not OBC A.
No, OBC. 1 minute,
Only
madam.
OBC.
Only OBC.
So why he has been classified under open backward class quota?
No, he has
Page
not.
21.
Page
If
21.
petitioner, if the student classified himself by his guardian as open backward class quota seat under open backward class category, then why he has been
Here
he's
the
been
question-
considered as
here,
OBC
here
A?
the entire scenario has changed. I
Yes.
tell your lordship, here the entire issue has changed because two categories are maintained. One is state list, one is central list. So he does not come within the purview of the central list. This Muslim Haldar. That is not within the purview of the central list. So, my lord, the question is, my lord, although he has secured a cutoff mark, therefore his case has been considered as open backward classes quota.
But he applied under which category?
OBC.
Rural OBC category, page 20. Admit card is set.
Yes,
Rural
OBC.
OBC. Page 20, my lord. Area, rural OBC,
এটা কি দেখাচ্ছেন? Admit
admit
card.
card. আপনার admit card দেখুন।
Area rural,
Rural, they have considered rural
yes, category OBC.
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 So area rural, he applied under rural OBC.
OBC.
Now, rural OBC, what was the cutoff marks?
Yes.
Rural OBC, my lord,
Come back to the relevant page, page 26.
Yes.
yes. 26 নম্বর।
Grateful to Lord.
Grateful. দাঁড়াও। হ্যাঁ,
Yes, rural OBC, boy,
yes.
77.50 is the cutoff marks.
My lord, he has been considered.
Yes.
His case has been considered. It is not that he has not achieved the cutoff marks. Question is, my lord, only embargo that is coming in between is the caste certificate.
That is
Not-
not acceptable.
That is not
Why?
acceptable. Because the caste certificate issued by the authority, lordship, kindly find page 18 of the writ petition. This has been declared as invalid on and from 2010. And that judgment is also with me. So, my lord, the question is,
That is Justice Tapobrata Chakraborty and
Yes,
Justice
yes.
Mantha.
That Supreme
So,
Court,
my
that
lord,
is
The Honorable Supreme Court, and this is a.
and there is no stay against that.
Yes.
Supreme Court has not granted any stay.
Yes.
Yes. So the question is,
So
Milord,
therefore, today petitioner cannot be considered as a OBC category candidate.
OBC category.
Now petitioner comes, then petitioner can be considered as a general category candidate.
General candidate.
In just a minute, in general category, petitioner is required to be classified under boy open unreserved.
Unreserved.
Boy open unreserved.
Yes.
Cutoff marks is 97.50. Petitioner is not coming within the zone of consideration. Yes.
86.25. Mala this a kind.
He himself said
Let him say.
95%.
Let him say.
Mala I said 95%.
So you are not coming
No,
within the zone of consideration. What
86.25 they have
You
considered.
mentioned yesterday that even if you are considered as a general category candidate, you are coming within the zone of consideration.
Mala,
Where is the case made out to that
Mala,
extent?
kindly but they have not, they are confusing because of that cut-off marks which has been published by the authority concerned 86.25.
No, that is as it appears from page 26.
Yes,
That is boy
rural unreserved 86.25. How they have stated before your loss in 95%, 97%.
On the question of marks, I am not disputing anything.
So now-
Why my learned friend is
No,
is
boy,
placing on
if you are not considered, try to understand.
Mala,
If you are not considered as
OBC.
OBC category candidate, as is rural OBC candidate, then you are to be required to be considered as a general.
General.
Under the general, come to page 26.
Yes, Mala, that is my case.
Please come to page 26.
86.
Just a minute. In page 26,
Lordship,
open unreserved boys,
boys.
97.50 is the cutoff marks.
Then my
You have stated in your writ petition paragraph 9 that you got more than 95%, more than 95%.
Now kindly come to assuming that.
So is it your case that you have obtained 97.50 or more?
Mala, it is my expectation, but here in
My
my
expectation.
Mala this that's Mala kindly come. They have considered 86 point.
Yes,
Mala kindly come to 86.
affidavit of service filed on behalf of the petitioner is taken on record.
the life of the Mala the kindly.
Next
consider-
paragraph.
They have not come with the 97%. That is
relates
not
to-
the true fact.
Matter relates to
This is the case of 86 point.
dictation.
They have considered under rural unreserved 86.25 consider.
matter relates to admission of petitioner in Jawahar
Navodaya Vidyalaya.
Navodaya Vidyalaya
Yes.
2, South 24 Parganas.
Yes.
2,
Yes.
Roman 2, South 24 Parganas.
Yes.
In class 6. Stop. Central Board of Secondary Education conducted Jawahar Navodaya Vidyalaya Selection Test 2025 on 18 January 2025.
Mean to it.
For Jawahar Navodaya Vidyalaya, where the father is petitioner or the son has come being
Father.
Presented by father.
wherein Jishan Rana Sardar being the petitioner appeared or participated participated upon classifying himself as OBC rural candidate, classifying himself as a candidate under OBC rural category. Stop. In support of same, admit card, which is at page 20, is relied upon. Stop. It is next part. It is submitted on behalf of the school authority as well as Central Board of Central CBSE, Central Board of Secondary Education, within bracket for short CBSE, that in view of the judgment of the Honorable Division Bench of this court, dated judgment date of the Division Bench.
এই তো আমার কাছে আছে।
Yes, please give me the copy of the judgment.
22nd May 24.
No, Division Bench judgment
Division.
of our court.
It is,
It is mentioned in the.
no, it is with me,
Supreme
it is with me.
Court order. Mentioned in the Supreme Court order at the arising out of 22nd May.
আমার কাগজটা কোথায়
In view of the judgment of the Honorable Division Bench,
লিখলাম যে?
dated 22nd May 2024,
দেখুন,
petitioner cannot be treated, or petitioner ought not be treated as OBC rural category candidate. Stop. It is candidly submitted on behalf of CBSE and the school authority that if petitioner would have been considered as OBC rural category candidate, in that event he would come within the zone of consideration. Stop. But in view of the judgment of the Honorable Division Bench, dated 22nd May 2024, at present the SLP appeal is pending before the Supreme Court, but it has not been interfered with.
No,
At
it has been, notice has been issued
না না
and delay has been controlled.
ওসব
It
ছেড়ে
is
দাও না,
fixed
বলতে হবে।
on 20th, coming, I think 20th August, next date.
ওইখানে রেখেছি। E2 7 9 এবার ঠিক আছে, কি বলবো?
হ্যাঁ কি বলছিলাম?
বাইশ এটা কি
আর বুঝলাম না, চলো মামলা।
না রুরাল তো আপনি ওপেনটা বলছেন 97 পয়েন্ট ওপেন
Same option is not left open. Stop.
বুঝিয়ে দেবে।
Next paragraph, it needs to be recorded here that the judgment of the Honorable Division Bench dated 22nd May 2024 has been assailed by filing special leave petition within bracket civil bracket close diary number 27287/2024 within bracket State of West Bengal and another versus Amol Chandra Das close bracket, and the issue is pending for consideration before the Honorable Supreme Court. Next paragraph. Stop. In the present case, next paragraph. No case is made out on behalf of the petitioner in the present case that petitioner should be treated as OBC rural category candidate. Therefore, in terms of the law prevailing, petitioner at best can be treated as open unreserved within bracket boy category. Stop. On perusal of a document at page 26 of the writ petition, it appears that the cut-off marks in connection with the aforesaid examination. Now, cut-off marks based on aforesaid examination has been fixed by the concerned respondent authority for open unreserved boy within bracket boy category is 97.50. 97.50. But there is nothing on record which goes to show that petitioner has achieved such cut-off mark in order to be considered as open unreserved boy category. Next paragraph. In view of aforesaid discussion, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent xerox certificate.
One second. Kindly give me 1 minute.
Next matter.
It is not open. It is a rural.
Next matter.
My application is a rural, not open. Rural is 86.25.
Call the next matter.
Item number 3.
I appear for the Madrasa Service.
Pursuant to your lordship's direction, my lord, I have.
Just a minute.
That is not a
এই 12টা বাজলে বুঝবো সাইলেন্স আছে
একবার দিন, সে বোধহয় নিয়ে চলে গেছে। সে নিয়ে চলে গেছে।
Yes. Have you filed a supplementary affidavit?
Madam.
Bringing on record the
Yes,
recommendations?
Yes, madam. This is the supplementary affidavit and this is the service of proof, madam.
Well, I have received that also.
দিয়ে দিয়েছে তো, right?
আমাকে দিস। আমি জানি না। Page 4.
So this is a transfer from the post of assistant headmaster to the post of assistant teacher.
Assistant teacher.
Well, with the last pay being same, not reduction of the last pay, because page 4 of the
What is
supplement-
your response with regard to transfer of a teacher to a post of clerk with the same scale of pay?
This would be wrong because of the reason that
Only payment is
No.
everything.
no, I'm saying the reason is not the payment. Of course not, because dignity is a big factor, of course. But the dignity,
It's virtually demotion.
no, that's a interesting
demotion.
point. But Lordship may kindly consider just two, three things. Number one, there are functional designations in variety of departments. How it can be understood, it is a functional designation, not a separate designation. Only question is there a separate scale of pay for it? For the post of assistant headmaster, the requirement is number of students. If there are 750, I believe, or 700, if number of students are there, intra-school, one assistant teacher through an internal selections can become a assistant headmaster. What right?
Automatically.
No, selection process he has to, of course. And then
The post has to be sanctioned, Mr.
absolutely,
Yes.
absolutely.
It's not automatic.
No, it
That
is not.
if in a madrasa,
Yes,
it is a school or madrasa.
it's a madrasa.
If in a madrasa there are 749 students.
Correct, correct.
At the moment, when the students roll strength enhanced to 750, there will be automatic conversion of an assistant teacher to the post of assistant headmaster. That is not the case.
Prior
No.
permission is required.
What I'm saying is, kindly consider. I mean, I have understood. These are the points, but well, this is going to be a very interesting point on this. I say that his fundamental designation and substantive post is assistant teacher.
How
And
can it be?
because
You may say on 100 times, but that is not established. Why? Because by following a selection process based on a prior permission
no
issued by the district inspector of schools,
selection process of
the-
what?
on an approved post, petitioner was appointed as an assistant headmaster.
Which is
And your commission is so fast. On the day this recommendation was
But that's
issued,
a- but that's a-
no, that is to be considered.
I'm saying-
Considering the nature of the order, on the day recommendation was
I-
issued,
I-
on the same day this transfer order was passed.
well, that I say that of course that can
Yes,
May I?
and your last occasion you argued at a time of correcting this order, it struck my mind.
Yeah.
I missed it. On 19th March 2025, OSD and ex officio director of Madrasa Education recommended.
may I-
On the same date, commission issued transfer
well,
order.
that's a separate issue.
Upon recording satisfaction.
But I understand.
Yes.
But I understand there are
And that is from the post of assistant headmaster to the post of assistant teacher.
That is not permissible. That is not
May I-
apparent from the
Madam, may I-
School
may I-
Service Commission rules.
Well,
also.
may I
In
just
other matters,
yes.
in spite of court's order, orders are not being carried out.
That's
What are the extraneous consideration, Mr. Badhor? Before making elaborate submission, I know your capability. You can
Well-
carry on for 1 hour, but I will not permit you in this matter. What is the extraneous consideration? First tell me.
I'm coming to that.
Yes.
May I get 5 to 10 minutes? I have got
Not
lots-
more than that.
Yes.
Yes.
I'm not
Be
asking.
precise.
Correct. I would be within 5 to 10 minutes. Well, may I?
How it is possible, Mr. Dhor?
Lordship is
On the day 19th of March, what is the on what time this recommendation was issued by the OSD?
we
Let
can-
me hear Mr. Bishoppoto Bosumontik,
Ma'am.
and on the same date, your chairman expressed satisfaction and transferred the petitioner from the post of assistant headmaster to the post of assistant teacher.
May I say, all of us have crossed 50. Kindly, my lord, let us. This is just a case. So, Lordship.
No,
may I- we can have it in a very, I can understand. I am not at all saying that kindly, I can completely understand. Now, may I only say that I may completely fail in answering Lordship's query. But, my lord, as a counsel, Lordship would, of course, appreciate when I genuinely try it. Kindly give me 5-10 minutes. I will genuinely try. Thereafter, I may fail.
Yes.
And well, these two considerations I will address, and I will definitely not consume any extra time. First, I say, my lord, that was the first thing which also struck me. Is it a demotion? Because that's a very genuine kind of question any reasonable person will ask. Then I was trying to find out that whether it can be a promotion, because it will be demotion if it is a promotion. Now, the post of assistant headmaster is not a promotional post. How that is understood is the memo clearly says that only entitlement is a special allowance. It is something like a city allowance or some other kind of allowances. So long he remains there, he gets it. Now, it is true, it is not without any selections, but selections intra-school. Therefore, my exact words would be this, Lordship, may kindly consider, I may be wrong, that this is a functional kind of designations. Now, in a functional kind of designations, he has 100% right to all the allowances which was given to him. And that has been protected in the order. Now, this is the first part of. To that effect, there is one judgment, my lord, I would be referring before your lordships. Z34. This is 2013 SCC Online Delhi. Lordship may kindly take paragraph 13.
Just a minute.
2013 SCC Online Delhi 937. Consultation will go to YouTube. Para 30, third line.
Paragraph, which paragraph you are reading?
Paragraph 13, my lord. May I just read, my lord? Just in view of the above, petitioner has not suffered loss of monetary emoluments. Petitioner has also not suffered any loss of rank or post because, well, this is the reasoning, because there is no specific post with specific pay scales of a primary wing commander in Asma. These are the others. All I'm trying to say is that there is no.
It has to be read in the context of the facts.
Of course.
What was the facts, Mr. Dhar?
Well,
that a primary teacher was entrusted with an additional charge of wing commander.
Exactly.
It is not an additional charge. Today, the case at my hand
Yes.
is not a case of granting additional charge. By following a selection process with the permission of the district inspector of schools, upon concluding the recruitment process, petitioner was appointed as an approved assistant headmaster.
Exactly. But here I join.
Additional.
Here I join issue.
Yes.
I say that.
In any other judgment, Mr. Dhar? Yes. Any other judgment? Yes.
May I just say one?
No. I have heard you so far. This judgment is also any other point.
The interpretations.
Please, any other point. Come to the next point.
Lordship.
Yes.
Ultimately, Lordship will deliver.
What can be done? See my list. Yes.
Okay.
Yes.
Then
any other point?
Yes, my lord. On the lordship's point, on the Malafide point, kindly take the 2000.
Persons are not getting pension. Every day mentioning primary, secondary, both determination. What can be done? I cannot give you more than 10 to 15 minutes. Yes. What are the other points?
By saying this, lordship is consuming time.
Yes.
Kindly reduce, my lord.
Yes. Any other point? Please come.
2024 SCC online. Well, I think copy I.
Very well, let it be decided on a affidavit. Let the interim order continue.
But, kind.
Yes, yes. If you are, if you want to argue whole hog, then Mr. Dhar, let it be decided on affidavit. This is a prima facie case. Let me injunct the transfer order, file and exchange your affidavits, get the matter heard.
Well enough, but kindly record might, because they might taste it. So kindly record
Yes,
that I am placing 2024 SCC online. I think copy I handed over last occasion, so copy is there. It is a very latest judgment concerning all the transfers and the principles. And this answers your lordship's query. There, it was a case, there was a extraneous reason. MLA sent a letter. Even in that case, the Honorable Supreme Court, after dealing with.
Yes, yes. Pay, 2024 SCC online SC 279.
Correct. Kindly see,
Yes.
paragraph 9, 10, 12, 15 and paragraph 14. Kindly have a look at. This is the latest paragraph 14 clearly says why I say he cannot take a point of malafide. It says that if he takes the point of malafide, he has to include the person.
Paragraph 14 you are relying upon.
Paragraph 14, my lord, the quoting portion, kindly see. There is.
Just a minute. It is also imperative to record of the judgment of this court in the case of Ratnagiri case. It is related to one of the pertinent principles constituted terms of the previous or personal circumstances.
14 and then 15.
Yes, in case of malafide, the against whom it is
And he has not
allegation is
correct.
made.
That's a must.
It has to be.
So, and paragraph 15, kindly see. Lordship have seen paragraph 15. The conditions, one, in view of the foregoing enunciations of law by judicial decisions, this court, it is clear that in absence of one, pleadings regarding malafide, two, non-joining the persons against whom allegations are made, three, violation of statutory provisions, and four, the allegations of the transfer being detrimental to the employee who is holding a transferable post. There I join one this. I will conclude just by showing this statute. Kindly see, my lord, 33D statute 2023 rule. And this judgment considered all earlier judgments on transfer.
What is your response with regard to violation of statutory provisions?
Yes, 33D.
Yes. Yes, yes.
The word is,
last occasion.
I think one copy I handed over. I say that this is a transferable job, and the word under 33D is any staff. It's not that only the teacher. And the contrary interpretation means that
Just a minute.
an internal affairs would make it non-transferable job.
Transport and special policy. But what is the provision that
Assistant headmaster.
can be transferred to the post of
The provision is 33D. May I read it? If the commission is satisfied on the recommendation of the director of madrasa education, which is there, that for public interest or for the welfare of the students of any madrasa, any staff. So that's the, my lord, last occasion I missed.
That word.
Yes.
Yes, any staff.
So therefore, that's the
Any
statute.
staff is required.
Any staff is required to be transferred irrespective of his or her willingness.
So therefore, the teacher can be transferred to the post of clerk. Now,
No.
if I go by your interpretation
Cannot be.
of 33D,
Cannot
then
be.
teacher can be transferred to the
Then
post
it
of
will
clerk.
be a separate.
Headmaster can be transferred to the post of assistant teacher.
No, cannot be. Well, I cannot,
Any other
because
point,
it,
Mr.
no, these are,
Huh?
and only last is page 37. His even appointment, that was also provisional, page 37. Because there are litigations are pending
Of the writ petition.
of the writ petition, page 37. His approval,
Approval of appointment for the post of commission is subject to the
well,
Yes.
otherwise it will be only exceptions. It is something like, my lord, everyone's service is transferable, but the moment someone becomes an assistant headmaster, this is not a transferable.
He can be transferred to the post of assistant headmaster.
That could be another interpretation. That could be another interpretation, of course.
Yes, applicants.
But that way.
Misappropriation of fund regarding midday meal, and not only that, I made presentation regarding
So if there is misconduct of the
appointment of head teacher, head teacher, and that my lord, not only that, my lord, page 36 additional point. My lord, looking to page
who are the where are your applications? Dekhi?
my lord, can 1 and can 2.
Just a minute. Can one has been preferred by whom? Yes.
Can 1 filed by the teachers, assistant teachers of Julian High Madrasa. Page 13,
Two teachers.
my 2 teachers.
Yes. So can one is by teacher.
Teachers.
Just a minute.
All the teachers made the representation one by one.
And can two is by
By the guardian.
one guardian.
My lord, here, my lord, one guardian.
Yes.
My lord, kindly.
Whether the guardian is a managing committee member.
Yes, my lord, not guardian is not the managing committee member, but I annex that he is, my lord, one is a student of that madrasa, my lord. I annex. Not only that.
How the guardian is affected by the conduct of the headmaster, assistant headmaster?
These are application of midday meal. My lord, first, my lord.
So for that, if there is any, if court goes by your submission that there are certain misdeeds committed by the petitioner, in that event, whether the madrasa is powerless,
My lord, we made representation.
whether the madrasa is powerless.
Not powerless, but now for last 2 years, no action was taken against that petitioner, my lord. So powerful.
But no, there is a headmaster in the school.
No,
Madrasa.
That is the point. But one time, service commission, my lord, recommended one headmaster, my lord, this assistant headmaster, my lord, not to join that headmaster. Recommended headmaster by Madrasa Service Commission, my lord. Kindly, my lord, ask my lord, Mr. Mukherjee, my lord, whether one headmaster was recommended for that Julian High Madrasa, but prevented to join in the said madrasa. Not only that, my lord, the High Power Committee report I have annexed in the, my lord, teachers camp 1, that High Power Committee report, this petitioner, this person appointed so many, at least 8 fake teachers, my lord. During that period, my lord, you will not know better than me. 20.
Well, I will direct them to recommend, if possible, recommend a candidate to be appointed as headmaster of the school. Madrasa.
Recommended.
Already recommended. So why has he joined? Already joined headmaster.
He has joined.
I am
Yesterday headmaster has joined.
Yesterday, that is not my, another thing, my lord, kind of.
And my lord, when they have made the complaints, my lord, kindly
Yes.
25 and no receipt there.
And one thing, my lord, page 36, kind of look into.
Page 30.
Dependent order, my lord. Regarding my lord, post of assistant headmaster, my lord, my client, my lord, filed repetition thereafter met. Kind of look into.
Which client? Guardian or teacher?
No, assistant teacher.
1 lakh rupees cost was imposed.
No, they are not that, assistant got misguided your notice, my lord. That is Jahangir Alam, my lord.
Where
Page
you have
34.
annexed?
My lord, page 34.
Of which kind?
Repetition.
Read petition.
They agree. Regarding the appointment of assistant headmaster, repetition 5/1 contesting assistant teacher.
Page, just a minute.
34 onwards, my lord, penultimate paragraph page 36. And that repetition is still pending, subject to the result of that repetition approval. That was written in the, my lord, already senior my lord, notice that page 37.
He cannot ask for any special equity. That's the order at 36.
The basis therefore is open to the student. Take it application and pass on appropriate consumption order. Step on the ultimate findings. It has been pointed by the student that the also and this one shall be. It was whose writ petition?
Second impanel candidate.
Oh, regarding appointment.
My lord, kindly turns to page 32.
Just a minute. Yes.
My lord, kindly turns to page 32. The order in the writ petition.
Just a minute. Anything more?
No,
This is you. Yes.
Page 32.
Page 32.
32. The order of the learned single just from where my lord appeal arose. Where entry order rejected.
Just a minute.
opposition reply. And that is also still pending. That was mentioned in the approval letter.
Affidavit, we have filed our affidavit, they have not
Filed any
reply. Another thing, my lord, in response to my learned senior friend submission, my lord, with regards to payment or increment, my lord, my learned senior friend intimated the court that he is only getting the some allowances,
Yes.
not the increment. My lord, kindly see the pay books. 4 and 5, existing pay and revised basic pay. Basic pay has also been revised. Four and 5. So I am not getting only the allowances.
No, basic pay is 9,000, 40,500. As an assistant headmaster, basic pay is 9,000, 40,500 with grade pay of rupees 4,400,
Matlab
which was
additionally-
4,100 in connection with post of assistant teacher. Yes, rightly submitted.
Matlab revised basic pay after one additional increment last 5.
Existing basic pay.
After one additional increment on.
No, you have to consider the initial basic pay. There was revision subsequently
That is
in
true.
connection with assistant teacher, in connection with assistant headmaster. That cannot be considered. But as an assistant teacher, his basic pay was 9,000, 40,000, 50. Same basic pay, 9,000, 40,000, 50 with grade pay of 4,100. Whereas as an assistant headmaster, 4,400. 300 rupees more.
That's
So matlab changed. Matlab another thing, my lord, matlab no rules is required to transfer assistant headmaster to the post of assistant teacher. In this regard,
Mr. Dhar, I am finally disposing of test it before the
matlab in this regard,
Otherwise, there will
But
be issue to that.
matlab I am relying.
Lordship on the last occasion.
About-
This is the
Yes, yes, yes.
Need to Milord take necessary instruction in
This is the last document I am relying.
Just a minute, one after another. Yes.
School Service Commission rules. My lord, I am appointed through the School Service Commission. Here, definition of the teacher does not include the assistant headmaster or assistant headmistress. So therefore, by amendment in the year 2017, the School Service Commission included the category of the teacher as assistant headmaster or headmistress. My lord, kindly turns to the next page. In the amendment.
Just a minute. The parent rule is Rule 33
Yes, my lord.
regarding
It is
transfer.
Madrasa.
Madrasa.
I am relying the rules of School Service Commission.
Why?
Because, my lord, I am appointed through the School Service Commission in 2001. Madrasa Service Commission Act came into effect in
But
the year
that is-
2008. Please.
আমার জন্য বলছি, this point was taken before the division bench. I have the judgment in a soft copy, presided over by the Honorable Justice who mentions. Now it is clarified. After all this, madrasa jurisdiction, madrasa, school service separate.
Yes.
No, I am only relying this because of the fact that for transfer of the assistant teacher or assistant headmaster or headmistress, separate rules is required. My lord, that is apparent from the 2017 amendment 10C, my lord.
Answer is he is a staff. He is a
Similar
staff.
to 33D, my lord, 4.
This court has to consider 33D.
Yes.
Absolutely.
And
Not
another,
nothing more than that.
My lord, only one page. I just forgot page 4 of a supplementary affidavit. My learned friend used a supplementary affidavit that the recommendation. Lordship may kindly have a look at page 4 of that. One sentence. Page 4.
and last submission, my lord.
I have said it.
No further submission. Please take your seat. Enough is enough. Yes, Mr. Basu Mollik.
Milord, I have
But-
sought for necessary as per Lordship direction.
Yes, let me see.
Given to me, Milord. 33D was quoted, Milord, and thereafter it has been mentioned that only for the purpose of welfare of the student in the school where is the student strength is less, Milord. That's why he has been
So
transferred.
yes, you transfer another teacher of Bengali to the madrasa.
Lordship.
Madrasa, why an assistant headmaster is to I say effect will be if I permit this,
Lordship.
then it will be misused, and that is it is not provided.
They have said that, Milord, that this petitioner has been recommended now, Lord. This petitioner was functioning as assistant headmaster, which is not a post to be filled up by any competitive examination. It is only post created as per necessity of the
Which paragraph?
paragraph 9, Milord. As per necessity, if the numbers of student increases.
That Mr. Dhar has already
Yes,
submitted.
that's what, Milord.
But in my madrasa, there are 3 other Bengali teachers, my lord. Only I am functioning as the assistant. There are 3 others.
See the position.
Lordship,
So the another teacher, assistant teacher could have been transferred. Why the assistant headmaster is being transferred?
Now, in para 4 also, Milord, kindly text once para 4. It may mention.
Yesho.
May I read, my lord?
No, last occasion you submitted many things, I remember.
Paragraph
No, in this matter you will not be, you will
will
not
remain
be.
here.
paragraph
want
two,
this?
Lordship, kindly text note, Milord, paragraph.
No, no, you are not given opportunity to open your mouth on last occasion. You shouted. Yes, no.
Paragraph 4, Lordship, kindly text once, paragraph 4 also.
Yes,
Milord, paragraph 4 also, Milord, I have mentioned that, Milord, that Milord, assistant headmaster is not a permanent sanction post for any institution. It has been mentioned, Milord.
yes, paragraph 4.
Lordship, kindly see, takes paragraph 4 of my report, Milord. It may be mentioned before this honorable court that the post of assistant headmaster is not a permanent sanction post for any institution. An assistant headmaster stroke headmistress is recruited by the managing committee stroke ad hoc committee stroke administrator of the institution from amongst the sanctioned strength of the teaching staffs of the same institution.
Now, is it a case, Mr. Bosumolli, that this school does not require any assistant headmaster?
But because here,
No,
Milord,
no. 750 is the criteria. Is it a case that this school
No,
does
no,
not
no,
require any
no.
assistant headmaster?
The number is there.
730.
Requirement is there.
7,000 students are there.
Correct. It's a
Yes, sir.
huge.
So then, if this post is downgraded, then this court can
But
understand
this is not a permanent.
that a post is downgraded from assistant headmaster to headmaster. No more assistant headmaster is required. If an independent decision would have been taken by the concerned respondent authority, question would have been different.
Right.
But when the school or madrasa is having more than 750, as Mr. taking a cue from submission of Mr. Dhor, if a madrasa is having more than 750 students, then why consider, in view of the fact that post is required in the madrasa, why the teacher will be transferred from the post of assistant headmaster to the post of assistant teacher?
Well, that's truly the fundamental question. But Lordship may kindly also consider that if it is a transferable or reverse, if I can say, can it be said whether the AHM, it is not at all a transferable at all?
Yes, you transfer him from the commensurating from one
Problem
from
would
the
be-
from the present
the
post to the
problem-
commensurating or equal post.
Problem would be that this post is an internal arrangement. So every school exceeding 750, there is an internal arrangement of their staff, one chosen based on a selections as an AHM.
Have you indicated that if the roll strength is 750 or more, then a post of assistant headmaster is required?
Here, Milord,
Well, there is a memo. I have the memo with me. This is at 671. It's in the headmaster's manual, page
295.
page 295. বইটা আছে আপনার কাছে?
paragraph 9, it has been only mentioned, Milord,
No,
as
that
per
is-
necessity if
that-
the numbers of students increase.
Correct. Well, this is
And Mr. Dhor on the same day,
which one?
on the same day.
Yeah, that's a lightning speed.
Then in hot
Like-
haste it has been done.
Well, sometimes true, my lordship, but sometimes
Sure.
well, deeply obliged.
Writ petition is heard at length in presence of the learned advocates representing the petitioner, comma, West Bengal Madrasa Service Commission. State response. Stop. 2 applications have been filed, being Can 1 of 2025 by one assistant teacher of Dhulian High Madrasa, Murshidabad, hereinafter referred to as said madrasa, and another being Can 2 of 2025 by 2 guardians of the said madrasa. Learned advocate representing applicants in both the applications are also heard. Now, প্রথমটা না ক্যান ওয়ানটা দেখো, ওয়ান টিচার বললাম না, হ্যাঁ, filed by 2 assistant teachers. Next paragraph. In the writ petition, recommendation, no, in terms of the next paragraph, in terms of the previous order dated 8 April 2025, supplementary affidavit has been filed on behalf of the petitioner and same is taken on. Stop. In the writ petition, next paragraph, in the writ petition, a recommendation memo, recommendation for transfer dated 19th March 2025, issued by the Secretary West Bengal Madrasa Service Commission, within bracket herein after referred to as commission, close bracket, is under challenge. Stop. By the said recommendation memo dated 19 March 2025, petitioner being an assistant headmaster of said madrasa has been transferred to Rahatpur High Madrasa, within bracket HS, district Uttar Dinajpur. Stop. It is submitted on behalf of the petitioner. It is submitted on behalf of the petitioner that it is submitted on behalf of the parties that impugned recommendation memo dated 19 March 2025 was issued based on order of OSD and EO, Director of Madrasa Education, West Bengal, dated 19 March 2025. Stop. Next paragraph. Therefore, stop. Therefore, it appears that on 19 March 2025, OSD and EO, Director of Madrasa Education, West Bengal, under Rule 33D of the West Bengal, under Rule 33D, from 12 after 8, 11:59.
No, it starts. There will be 2 bells. I think
বেশি করে এটা টাইম তো ঠিক আছে আপনি তো হ্যাপি ঠিক আছে না টাইম পারফেক্ট
Under Rule 33D of the West Bengal Madrasa Service Commission, recruitment within bracket selection and recommendation of persons for appointment and transfer to the posts of teacher and non-teaching staff, close bracket rules 33. Rules 2023 within bracket hereinafter referred to as said rules of 2023, close bracket. Sentence number 4. Rules টা বাদ দিই। না না সেন্টেন্স ওই রুলসটার আগে যেটুকু বলেছি recommended না decided অ্যাপ্লিকেশন হয়ে গেছে এটা হয়ে গেছে 1181 এটা ইন্ডিকেশন আছে decided to transfer the petitioner from the said madrasa to Rahatpur High Madrasa within bracket HS, Uttar Dinajpur. In the interest of public service. Stop. It is also stated. It is also stated in the transfer order that there is dearth of assistant teacher in Bengali under honors PG category in Rahatpur High Madrasa. And that is the reason for transferring. And that being the reason for transferring, or that being the reason to decide that being the reason to decide the petitioner to transfer on applying provisions under Rule 33 within bracket D of the said rules of 2023. Next paragraph. Mr. Shunit Kumar Rai, learned advocate representing the petitioner, while questioning আচ্ছা তার আগে একটা সেন্টেন্স দাও Based on such order dated 19 March 2025, on the same day, a recommendation for transfer was issued by the Secretary, West Bengal Madrasa Service Commission, or by the Secretary of the Commission. Based on the issued by the Secretary of the Commission. So, next paragraph. Mr. Sunit Kumar Rai, learned advocate representing the petitioner, while questioning the validity of the decision to transfer the petitioner, has categorically submitted that petitioner is presently working as assistant headmaster of said madrasa, based on approval accorded by the District Inspector of Schools AC Murshidabad, vide memo dated 22nd March 2022, with effect from 31st Jan. No, with effect from the beginning. 2022. It is further submitted that in terms of the permission accorded by the concerned District Inspector of Schools AC Murshidabad, authority of said madrasa conducted a selection process in accordance with the relevant recruitment rules, and the petitioner was selected for being appointed in the post of assistant headmaster, and accordingly, based on approval granted by the District Inspector of Schools, within bracket AC, close bracket, concerned, petitioner is functioning as assistant headmaster of the said madrasa. Stop. It is further submitted. No, stop. Appointment of petitioner as assistant headmaster was questioned by a writ petition being WPA 2208 of 2022, wherein a coordinate bench passed an order, passed direction to exchange affidavits. But selection of the petitioner as assistant headmaster was not interfered with at the interim stage. Stop. Such order dated 24th February 2022 was assailed by preferring an intra-court appeal being MAT 368 of 2022, which was disposed of video order dated 6th May 2022, passed by the Honorable Division Bench, wherein order passed by the coordinate bench on 24th February 2022 was not interfered with, 7 except an observation was made that appointment of the petitioner was made after filing of the writ petition, connected writ petition, petitioner in the present writ petition shall not claim any special equity on the basis thereof, and issue was kept open before the honorable single bench to take decision on exchange of affidavits. Stop. Since petitioner was transferred by the impugned recommendation dated 19 March 2025 from the post of assistant headmaster to the post of assistant teacher, it is submitted that such transfer is a punitive transfer, which is not tenable in view of the relevant provisions of the said rules of 2023. Stop. Next paragraph. Mr. Pratik Dhar, learned senior advocate, represents West Bengal Madras Service Commission. He has submitted, he made submissions to defend the transfer order dated to defend the recommendation for transfer dated 19 March 2025. Firstly, based on the said transfer order, wherein it has been stipulated that the petitioner now based on transfer order dated 19th March 2025 issued by the OSD and EO, Director of Madrasa Education, West Bengal, wherein it has been stipulated that petitioner shall be permitted to draw pay as per last pay certificate issued by said madrasa. Stop. Therefore, it is contended that financially petitioner will not be loser on his transfer from the post of assistant headmaster to the post of assistant teacher. Stop. It is also contended that such decision to transfer the petitioner was taken in terms of Rule 33D of the said rules of 2023, wherein authority has been conferred to decide transfer of a teacher / assistant headmaster or to decide the transfer of any staff working in madrasa upon recording satisfaction on the recommendation of Director of Madrasa Education. Stop. According to the commission, connotation staff as it is used under Rule 33 within bracket D includes all category of staff working in madrasa, including assistant headmaster. Stop. It is specific. Stop. It is submitted that since by giving pay protection, petitioner has been transferred from said madrasa to another madrasa, demotion from assistant headmaster to the post of assistant teacher by way of transfer is immaterial. Stop. It is also contended that post of assistant headmaster is not a permanent post. Creation of such post depends upon the role strength of a madrasa, and if if role strength crosses 750 or more, in that event concerned state authority creates such posts by according necessary approval. Stop. There was no competitive examination conducted by the commission for filling up the post of assistant headmaster, and by way of an internal selection process, since post of assistant headmaster is filled up, no right accrues in favor of the petitioner to lay a claim that he cannot be transferred from the post of assistant headmaster to the post of assistant teacher in a situation where pay protection is granted. Stop. Submission is, next paragraph, submission is also made by Mr. Bosu Mollik, learned additional government pleader, representing the state respondents, which is in tune with the submission made on behalf of the commission. Stop. In support of same, a communication dated 23rd April 2025 issued by the OSD and ex officio Deputy Secretary, OSD and ex officio Director of Madrasa Education West Bengal, কি বললাম, in so and so, enclosing a writing is placed before this court and same is taken off. Next paragraph. On behalf of Mr. Dhar, representing the commission, in order to buttress the case of the case of commission, or Mr. Dhar, learned senior advocate, in order to buttress the case of the commission, has relied upon judgment reported in a judgment of the Honorable Supreme Court reported in 2013 SCC Online Delhi 937, Ritu Kaushal versus Director of Education and others, close bracket, and another judgment reported in 2024 SCC Online SC 279, within bracket, Kubi Lombi versus State of Arunachal Pradesh and others. Next paragraph. Mr. Chattopadhyay, learned advocate, appearing on behalf of the applicants in both the applications, submits that there are certain allegations against the petitioner in functioning as assistant headmaster of the said madrasa, and in this regard representations were made before the concerned respondent authorities against the petitioner. Stop. According to the applicants, if petitioner is transferred by giving effect to the impugned transfer order dated 19 March 2025, said madrasa would be benefited. Next paragraph, having considered the submissions made on behalf of the parties, this court is required to consider Rule 33D of the said rules of 2023, which is reproduced, which is quoted below. Much emphasis has been laid on the expression used in Rule 33D, that is staff, i.e. staff, quote unquote. And it is contended on behalf of respondents that staff, since it is contended on behalf of the respondents, since staff includes assistant headmaster of madrasa, there is no impediment in transferring the petitioner from his post of assistant headmaster. While considering such submission made on behalf of the commission, this court cannot brush aside the fact that by the recommendation for transfer dated 19 March 2025, petitioner has been transferred from the post of assistant headmaster to the post of teacher, which in effect, post of assistant headmaster to the post of teacher, which appears to be a punitive one. Notwithstanding granting pay protection. Stop. Though granting pay protection. Stop. It is known, it is established practice that the post of assistant headmaster is an approved post which is created by according necessary sanction by the state authorities. If a post is available in madrasa, if a post of assistant headmaster is available in madrasa, such post is required to be filled up by following a recruitment rules. Stop. Petitioner participated in the selection process conducted by the said madrasa authority, and on being selected, he was appointed and as assistant headmaster, and such appointment was approved by the concerned district inspector of schools AC Vide, memo dated 22nd March 2022. Stop. It needs to be recorded herein that the writ petition being WPA 2208 of 2022 is pending, wherein challenge has been laid against selection of the petitioner as assistant headmaster of said madrasa. Issue travelled before the Honorable Division Bench, wherein issue travelled before the Honorable Division Bench, and by passing an order dated 6th May 2022, issue was kept open, and single bench was directed to decide the selection of the petitioner as an assistant headmaster of said madrasa on exchange of affidavits. Stop. The writ petition being WPA 2208 of 2022 is still pending. Stop. If at this stage impugned recommendation for transfer dated 19 March 2025 is given effect to, in that event, the writ petition being WPA 2208 of 2022 shall be rendered infructuous. Since the issue involved in this writ petition is appointment, involved in this writ petition is selection of the petitioner as assistant headmaster of said madrasa. Next paragraph. Elaborate argument has been, though elaborate argument has been advanced on behalf of the commission, that it is open to the commission to transfer it is open to the authority to transfer assistant headmaster of one madrasa to the post of assistant teacher in another madrasa. But Rule 33D postulates a recording of satisfaction by the commission while transferring a staff of madrasa. OSD and EO, Director of Madrasa Education, West Bengal, passed an order on 19 March 2025 for transfer of the petitioner, and on the very same date, that is on 19 March 2025, Secretary West Bengal Madrasa Service Commission issued recommendation for transfer. But what was the satisfaction recorded in support of such transfer is not placed during the hearing of the writ petition on behalf of the commission. Stop. The reason for transferring the petitioner is dearth of Bengali teacher in Rahatpur High Madrasa within bracket HS. But it is contended on behalf of the petitioner that apart from him, there are three other Bengali teachers working in the said madrasa. Stop. Why petitioner who is working in the post of assistant headmaster was chosen for transfer when other Bengali teachers were available in the said madrasa is unknown. This consideration is required to be made in view of the fact that petitioner holding the post, holding petition in view of the fact that petitioner at present is functioning as an approved assistant headmaster of said madrasa, and in connection with selection of the petitioner, a writ petition being WPA 2208 of 2022 is still pending. And in the event such transfer order is given effect to, petitioner will be demoted from the post of assistant headmaster to the post of assistant teacher. Stop. This goes to the root of the matter. Stop. Mere expression of, mere use of expression staff, quote unquote, in rule 33 within bracket D does not absolve of the responsibility of the concerned respondent authorities to take into consideration as to why the petitioner working in the post of assistant headmaster is to be transferred to the post of assistant teacher of another madrasa when other Bengali teachers are available. Next paragraph. In Ritu Kaushal Supra, Honorable Supreme Court was considering the fact situation where primary teacher working in additional charge of primary wing coordinator was relieved. And taking note of same, certain observations were made that the same does not confer right upon the incumbent to claim such status permanently. Or such elevated status permanently. Stop. But in the present case, petitioner is holding the post of assistant headmaster on granting approval by the district inspector, by the concerned district inspector of schools AC, after being selected for the said post on conclusion of a selection process following a recruitment rules. Stop. Therefore, ratio of Ritu Kaushal Supra does not come in aid of respondents, respondent authorities. Stop. In Pubi Lama Supra, in paragraph 15, Honorable Supreme Court has held certain situations held in absence of certain situations, it is inappropriate to make out a case of, it is inappropriate to conclude that it is to conclude a case of malafide. But exceptions which have been carved out in paragraph 15 needs consideration so far present case is concerned. It has been specifically observed in paragraph 15 that violation of any statutory provision is one of the exceptions. Stop. There is nothing found in regulation 33, in rule 33D of the said rules of 2023 that an incumbent holding post of assistant headmaster can be transferred to the post of assistant teacher in another madrasa by demoting him, by demoting the said incumbent without following any procedure. Stop. Next paragraph. In view of aforesaid scenario. না তারপরে করো আরেকটা আছে applications are also taken in both the applications are also taken into consideration which are filed at the instance of 2 guardians and 2 assistant teachers. Stop. These assistant teachers participated in the selection process? No. 2 guardians and 2 assistant teachers. Stop. If they have grievance against the petitioner due to certain alleged misconduct committed by him, it is open to them to bring it to the notice of the concerned authorities for taking appropriate steps against him. It is apprised during course of hearing today that though post of headmaster of said madrasa was lying vacant for considerable period of time, but recently a candidate has joined the post of headmaster. Stop. Therefore, the said madrasa authority madrasa authority can take steps in accordance with law in the event of any misconduct of the petitioner. Next paragraph. Next paragraph. In view of aforesaid scenario, impugned order dated impugned order dated 19 March 2025 issued by OSD and EO Director of Madrasa Education West Bengal and the impugned recommendation for transfer dated 19 March 2025 issued by the Secretary West Bengal Madrasa Service Commission stands set aside. Stop. Writ petition is disposed of. Consequently, the applications taken out by the applicants are also disposed of. Stop. Urgent Xerox certificate.
Well, only one correction. One judgment was of a Delhi High Court. So Pubi was Supreme Court. Another was not. It was the Delhi High Court.
Now Pubi Lama is Supreme Court.
That's a Supreme Court. But
ঠিক বলেছে দেখি ওই যে জাজমেন্টটা যেখানে বললাম না দুটো জাজমেন্ট দেখো ওই ঋতু কৌশল রাইট SCC online Delhi.
Yes, that's a Delhi. And my lord, other is one word. The what?
Just a minute,
Yes.
Let me correct it. 2013 SCC online 937. ওইটা দেখো 2013 SCC online Delhi. SC না SCC online DEL 937 না উপরে বলেছি দেখো 2 judgments of the Honorable Supreme Court. দেখো ঠিক তার আগে বলেছি ওই যখন যেখানে মিস্টার ধরে সাবমিশনটা রেকর্ড করেছি ওখানে বলেছি সম্ভবত yes relied upon 2 judgments of the Honorable Supreme Court. He has relied upon 2 judgments of the 2 judgments, one delivered by the Honorable Supreme Court and another by the Delhi High Court. এইভাবে হবে বুঝতে পেরেছো এবার এই ঋতু কৌশলটা যেখানে যেখানে বলছি 237 and 937 ওটা সব জায়গায় Delhi High Court হবে not Supreme Court.
Possibly only one
Yes.
place. Yes.
Recording your submission. Yes.
Only,
What are the other?
only one thing? Lordship has used the word permanent as my submissions instead of the word permanent. If Lordship uses substantive, because I say that a post of AHM, it is not a substantive; it is functional designation. Only this.
একটা জায়গায় দেখবে আমি রেকর্ড করেছি সাবমিশনটা ইজ এ পোস্ট অফ অ্যাসিস্ট্যান্ট হেডমাস্টার ইজ এ পার্মানেন্ট ইজ নট এ পার্মানেন্ট পোস্ট, এটা ইজ নট এ সাবস্ট্যান্টিভ
Yes.
পোস্ট করে।
But deeply applied.
আচ্ছা এইগুলো টেক ইট ব্যাক, দিস আর নট রিকোয়ার্ড। Yes.
Item number 4.
My lord, I am appearing on behalf of the petitioner.
I'm appealing for the statement.
I am for the headmaster, your lordship. We have already submitted the pension book and the service book to the DI.
Just a minute. So you have prepared the service book as well as pension paper file.
Lordship, we have filed it.
It has
And-
come to the office of DS and DS has come. It is under process. It will take some time. It will be waiting.
When you have submitted it?
On 8th of April.
8 April.
It was 2 weeks time was granted by your lordship and it was submitted within the stipulated time.
Who is the petitioner?
Petitioner is him.
Husband of the
Wife of the deceased the assistant teacher.
but is service book of late Dipali Bokshi.
That is the name of the assistant teacher who has expired. Dipali Bokshi was the assistant teacher and his wife, present petitioner, is Anita Pakrashi.
Dipali was
Lordship,
is
assistant
a ma-
teacher's name.
is a
Husband's
male,
name.
male
Husband's name.
teacher.
Male teacher, your lordship.
Dipali.
Okay.
I have never found Dipali, the name of a male candidate.
Dipali Bikash.
That's why Dipali Vikas. That's why I could not reconcile. Why you have not forwarded it to the Commissioner, Director of Pension Provident Fund Group Insurance?
Some holidays are there. And
One is very, one stand is very, this court expresses apprehension that the pension file would be sent to the Assistant Director of Accounts, Kolkata. Whenever it is sent, there will be objections. I never found that assistant director of accounts or director of accounts does not raise any observation. Always observations are made. So have you obtained a nod or a vetting from director of accounts, assistant director of accounts? It would be sent. Then within 2 weeks you will be able to send it to the director of pension.
My internal vetting from PS.
Yes.
Some internal vetting is equal.
So it was submitted on 8 April. Today we are on 24th April. What you are doing for such a long time? It's an issue where the teacher died in on
1991.
1991.
That is admitted.
You are for the petitioner?
Yes.
Yes.
I personally talked to DI. By today, everything will be sent. Everything. I personally talked to him.
Well, I am granting you 7 days time. Come back. Issue. In terms of the order dated 27 March 2025, service book and pension file of the service book and pension file of the petitioner have been reconstructed by respondent number 5 and 6.
Headmaster.
By the respondent number 6.
Headmaster.
By the respondent number 6, and same has been submitted before the office of the District Inspector of Schools AC, Kolkata, on 8 April 2025. Stop. Learned advocate representing the District Inspector of Schools AC, Kolkata, has prayed for fortnight time to complete the process to settle the claim of the petitioner. Now, to settle the family pension case of the petitioner, and to forward the same to the Director of Pension, Provident Fund and Group Insurance. Next paragraph. Since necessary pension papers were received by the office of the District Inspector of Schools AC, Kolkata, on 8 April 2025. The District Inspector of Schools AC, Kolkata, is directed to forward the pension case of the family pension case of the petitioner to the Director of Pension, Provident Fund and Group Insurance, being respondent number 3, by 10 days from date, on compliance of necessary formalities. Stop. Stop. On receipt of family pension case. Now, on receipt of necessary papers relating to claim of the petitioner for release of family pension, respondent number 3, on compliance of formalities, shall issue pension payment order by fortnight thereafter. Next paragraph. Respondents are directed to release by fortnight thereafter. Stop. Next paragraph. List the matter under the same heading on on 9th June 2020.
Opening date.
Yes.
Opening date of the code of the summer vacation.
On 10 June 2025, to see the steps taken by the authorities for releasing family pension in favor of the petitioner. For releasing family pension in favor of the petitioner. Next.
Item number 5.
Dear my lord, petitioner is a para teacher. Petitioner applied for the post of assistant teacher upper primary under para teacher category. Petitioner was called for verification. Petitioner went for the verification, online and offline verification. Thereafter, my lord, a notice was published in 2024 for personalities, but since the election was ensuing, it was immediately withdrawn. Thereafter, again, my lord, there was a verification, petitioner participated. My lord, thereafter,
Verification of testimonials.
no, very
But you
online
have said, you have
testimony.
submitted that the physical and online verification was over.
Yes.
Yes.
Yes, ma'am. Thereafter, my lord, suddenly the rules does not provide so. A list was published, my lord. If your lordship kindly come to page 46. No, I will place this first.
Yes.
My lord, this is for the information of all concerned that a tentative list of eligible candidates has prepared after event hereby uploaded in respect of the recruitment process of first SLSC 1680 for upper primary level of classes for the 10% seat reserved for parents. This list does not contain the name of those candidates who have already appeared for personality test for the 90% segment for which the first phase counseling is going on at present, and those candidates need not thereafter. It may be noted that inclusion in the above list does not guarantee inclusion in the personality test list, which would be determined strictly in accordance with the prescribed ratio of 1:1.4 of the vacancy and the relevant selection rules. A calculation of age limit will be subject to final outcome in so and so. All relevant documents will be verified, checked once again at the time of personality test or even thereafter up to a stage manner. Therefore, the attached list should not be considered as the final list of eligible candidates under any circumstances.
Yes.
My lord, this shows that certain names have been published. These names may be included in the list for personality test, may not be. But if someone is not in the list, then my lord, according to my understanding, he is definitely not eligible for personality test. My name is not there. The rule does not provide for any such tentative list. So, my lord, if a list of interview list has to be prepared in terms of the rules, according to the cutoff has to be fixed, my lord, in terms of 1:1.4 of the vacancies, calculating the marks as provided in the rules, that is the academic qualification and TET weightage. My lord, this list does not contain my name. I have filed this writ petition saying that I am eligible, so my name should be there in this list. It may so happen that my name subsequently featured.
On what basis you are asserting that you are eligible?
My lord, I have the qualifications to be appointed as a para teacher. Now, sorry, my lord, as a assistant teacher. Now, whether I come within the cutoff or not, that has to be ascertained in terms of Rule 12.4. You have to publish the list disclosing who are eligible for interview list. Then only, my lord, I can see that whether I have come within the cutoff or not. Because I know my marks. I know my marks in TET. I know my academic marks. So unless, my lord, the cutoff is shown, I cannot say that I am below cutoff.
Let it be decided on affidavit. Yes.
My lord, only one thing.
No report.
No. Rule 12.4, my lord, kindly see Rule 12.4.
That will be considered time of affidavit at the final.
Lord, vacancy filled up, my lord.
Yes, ultimately, if it is found on exchange of affidavit at the final hearing that you came within the zone of consideration, appropriate direction is to be
That
given.
may be.
Yes.
I have taken instruction, petitioner is below the cutoff.
Where from?
And the rule provides for what I am to do finally. My intermediate exercise, that is not prescribed in the
Yes,
rules.
it is provided in the rules.
The grievance of the petitioner is, after participation, grievance of the petitioner is, being one of the candidates in first state level selection test 2016 within bracket assistant teacher for upper primary level of classes, which is confined to 10% is reserved for para teachers. Stable ball. ঠিক আছে, his name, his or her,
Her, my lord.
her name has not been included her name has not been included in the list of eligible candidates published in terms of notification dated 27 November 2024.
My lord, preliminary list of eligible candidates, that is the heading.
List of eligible candidates, page 46.
My lord, preliminary list.
This is to inform for concerned authority that tentative list of eligible candidates.
Notification says preliminary, that is why.
List of eligible candidates, হ্যাঁ তারপর কি বললাম?
List of eligible.
Yes. Stop. According to the petitioner, exclusion of name of the petitioner from the list which was published in terms of notification dated 27 November 2024 takes away her right to participate in the ensuing personality test. Stop. It is contended that petitioner the marks of the petitioner is above the cutoff marks. Therefore her name should feature in the said list. Next paragraph. On the contrary, the learned advocate representing West Bengal Central School Service Commission submits that the marks allotted to the petitioner in the aforesaid selection process is below the cutoff marks. Is below the cutoff marks fixed by the commission. Stop. Considering the respective submissions made on behalf of the parties, the issue needs to be decided on exchange of affidavits. Considering the submissions made on behalf of the parties, it appears that the issue needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Selection of candidates for the post of assistant teacher in connection with first SLST 2016 assistant within bracket. Now, selection of candidates in the post of assistant teacher in connection with first SLST 2016 upper primary for 10% seats reserved for para teachers shall be subject to the result of the writ petition.
Then the entire, all candidates are subject to one candidate's
In that
success.
event, let one post be kept vacant.
No, let the steps taken abide by the result of the writ petition.
One post.
For
some
one candidate
protection.
will,
One post may be kept.
the entire selection process.
In any event, my lord, vacancies are more candidates.
The steps taken, the steps taken in connection with the aforesaid selection process shall abide by the result of it.
And that
My lord.
goes unsaid actually.
Sorry.
Of this writ petition. Affidavit service filed on behalf of the petitioner is taken on. Yes.
Item number 6.
For the petition.
I appear
I must
for the respondent number 6 and 7.
Kindly, whether your lordship will take up the matter or not.
Yes.
Page 76. Can you pass?
You better lordship kindly.
Second paragraph.
Page 76.
Page 76.
During the hearing.
Which issue. The writ petition stands released on personal ground. The writ petition stands released on personal ground. কি করেছো কালকে ছোট ছোট অর্ডার গুলো মাথা দাও না কোনো সেটা এখানে ফটফট করলে সবসময় হয় আমি কাল 8:30 পৌনে 9টায় বেরোচ্ছি তুমি যে একটু মাথা দাও একটু চলে গেলে হবে ঝটঝট করে আর তারপরে কাজ শেষ করে ওইরকম ভাবে যেমন তেমন করে কাজ শেষ করে কি হ্যাঁ the writ petition stands released on personal ground and be placed before the honorable the chief justice for assignment next আবার কি upper primary level of schools না 10% is না 10% is reserved for para teachers next
Item number 7.
I'm for the school authority. This was taken up for your consideration on last week, my lord, last 17th, my lord. The issue.
Yes.
Issue involved in the petition, my lord. I am the assistant teacher. I have retired from the post of my lord assistant teacher in the
who is for the school authority
my lord, I am for the school authority. On that day, my lord, Mr. Headmaster personally appeared, my lord. I retired my teacher in the assistant teacher post in last October 2024, but my pension payment order has not been issued on the ground that my wife, she is also a teacher in service, my lord. She lodged a complaint before the district inspector of schools, specifically mentioning that criminal case is pending against me, filing between the parties 498A the Domestic Violence Act. That is the reason, my lord, my pension payment paper has been not rejected, my lord, it returned before the school authorities, then objected by the district inspector of schools. My lord
who
was
is appearing for the state last occasion Shanti
occasion
Ranjan
for
Das
appeal.
Devashish Bhattacharya where are they
Appeared.
there's a case of pension so
Yes.
therefore the state representation is required
My lord, somebody appeared on last occasion, my lord.
when school appears state does not appear when state appears school is not represented
My lord, then kindly make it not today. I shall inform Mr.
not today
Oh.
inform the learned advocate representing
my
state
Not today.
next
Item number 8.
yes
I'm for the petitioner led by Mr. Sudeep Ghosh Chaudhary. This is my affidavit of service.
yes what is the matter about
This is a transfer matter. Lastly applied on 15 September 2022 on self-medical ground. Page number 24.
page 24
Yes, Sush.
yes self medical ground
Yes, Sush.
yes please place the facts when that transfer application was made
Lastly made on 29th September 2022.
come back tomorrow
Item number 31.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Writ petition stands dismissed for default. Parties to act on the server copy of this order downloaded from the official website of this court. Next.
Item number 32.
Well, I'm for the petition in this matter. I'm for the sustainable service. Mr. Shumonde informed. It was taken up yesterday. Mr. Shumonde did not appear. So
He is appearing for the DPST.
DPST Makura. It's an intra-district transfer. It's pending at the end of the school.
Who is for the board?
Board is not the required party.
Is not required intra-district.
Not intra-district.
But the commission that DPSC is required.
I requested him yesterday. He told me I'll come.
Shumonde.
He came after the matter was called on. But I requested him. He said. But it's pending.
Place your case.
Yes, Malad. Kindly come to page 37. That is the status.
Page 37.
Page 37. This is the status.
Applied on Utsotsy portal.
It is a general transfer ground. He has completed more than 5 years of service. Kindly see the bottom portion. 25th August.
You applied before the sub-inspector of the circle on 25th August.
August, yes.
Then circle to DPSC secretary.
Sent with the remarks that PTR is surplus now presently for
on the ground of distance.
Yes, general transfer. I'm eligible after 5 years.
5 years completed.
5 years completed. Confirmed teacher, and there are 3 teachers and 46 students presently. So, my lord, I'm eligible for consideration.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made application for transfer on general ground within bracket distance, or on applied for transfer on the ground of distance in between the present school of the petitioner and his place of residence on 25th August 2022 on Utsotsy portal. Stop. It is submitted that sub-inspector of schools of the concerned circle forwarded the transfer application of the petitioner through portal to the district inspector, to the district primary school council, Bankura. For taking decision on the transfer application of the petitioner, but decision is still awaited. Stop. Next paragraph. Respondents are represented by learned advocate. Stop. Next paragraph. It is submitted on behalf of District Primary School Council Bankura that if appropriate authorities directed, transfer application of the petitioner shall be decided in accordance with law. Next paragraph. In view of submissions made on behalf of the parties, writ petition stands disposed of, directing Chairman District Primary School Council Bankura being respondent number 6 to decide the transfer application of the petitioner in accordance with law by 6 weeks from the date of communication of this order. Stop. The decision to be taken by the respondent number 6 shall be communicated to the petitioner by 10 days thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner.
Grateful to
Urgent
Lord.
Xerox certificate copy. Deeply appraised. তাহলে কষ্টটা দুবার লিখে ফেলেছি ওই affect
Item number 33.
In item number 30,
Yes,
for the
commission.
district primary school council, Paschim Medinipur, my lord.
This is also same.
My lord, in this matter,
This inter-district, but this is not through online portal. Subsequently, to after suspension, page 39.
within prescribed performer.
There is no prescribed performer for primary. There is no. The Lordship considered on the yesterday on that matter.
Yes, but there was a submission that for intra-district transfer, inter-district transfer, there is no prescribed performer.
Not for
But for intra-district transfer, there is a prescribed.
That depends on the DPSCs. They have their individual proformas at different times. They come with certain proformas, but here there is no such proforma.
There is no prescribed performer.
my lord, usually, my lord, they applied before the, my lord, chairman through the, my lord, sub-inspector or the school authorities, my lord, and my lord, thereafter.
But for making application for transfer intra-district,
my lord, now
so far Paschim Medinipur DPSC is concerned, there is no prescribed performer.
there is no place, only the, my lord, in many cases I have seen, my lord, only the application.
Application is
Submission.
yes. So
Now, my lord,
where is your application?
my lord,
39.
my lord,
I will hear you.
your lordship,
Wait,
my lord,
page 49.
39. 39.
59.
39. So joining is at 2019. I've completed 5 years of service. I'm also a surplus teacher in the school. The application.
33. So it has been forwarded to the DPSC.
No, it has been sent to all the authorities. They are sitting tight over the issue.
Why sitting tight? Circle inspector.
No, they will not do. Unless there is an order from your lordship, they will not do.
So why circle inspector has not forwarded it?
But that
Yes, what you.
my lord, in respect, my lord, when this application was made, my lord, it is. COVID date bolo?
I'm telling the date.
You tell me, page 39.
No, it is of 4th March.
Why you are asking
4th
me?
March, my lord,
3rd March.
my lord, now, my lord,
Page 39.
The date is possibly not there, but
Date February 2025.
now,
yes, right hand side, 20th
Yes.
February.
28 February 2025, my lord, the Ushosri portal, which, my lord, which is applicable now, my lord, it is suspended.
So what?
Therefore, no scope of, my lord, filing.
I have decided, division bench has decided, suspension of portal cannot take away the statutory right of the applicant teacher to get transferred.
Lordship,
Issue is no more res integra.
lordship. In that event, my lord, it can be considered. But one thing only I shall, my lord,
The decision of this.
my lord, lordship,
Division bench.
lordship. My lord, only thing is that, my
Issue
lord,
is no more res integra, even if suspended.
my lord, in the petition, my lord, he has, my lord, submitted, he has stated that, my lord, ratio of, my lord, people teachers ratio is 50
You
is
take
to,
decision in accordance.
my
with
lord,
that.
I shall take,
Yes.
lordship. Here it is more. Yes.
2-3 grounds.
It is intra-district.
The what role board is to be will play in intra-district transfer?
No, it is not probably subject to say intra. Might be switching to.
Paschim Medinipur.
He has also,
Yes, yes, point it out, point it out. If it is
Haldia-
inter-district transfer, then
No, my lord. No, Purvo. No, he's right. He's right.
my lord, he has wrongly stated the Haldia is, my lord, under the Purvo Medinipur.
you are representing
Paschim Medinipur.
Yes, under which I'm
Therefore,
presently working. Right. I'm sorry. It's my mistake. My
and cost title.
Manipur, I just got.
Whoever says
No, I'm sorry.
Yes.
Sorry, I'm extremely
district
sorry.
transfer.
Between Purvo Paschim, my mistake, my lord. Kindly forgive me for that. I just got confused with the Purvo Paschim Medinipur. No. From Paschim to Purvo. No,
Because of
it's
that,
my mistake.
Haldia circle itself, my lord, comes under the jurisdiction of the.
My mistake,
You should
my
not commit Purvo Paschim mistake.
I understand. No, I'm sorry. It is my mistake. Absolutely my mistake.
But I'm on my lord, page 39.
So you are seeking transfer from Paschim Medinipur to Purvo Medinipur. Then it is to be decided by the
The board.
board.
Absolutely.
Board.
Absolutely.
Yes.
Sorry.
Now,
I am eligible, just page 39, this transfer application.
Yes.
The bottom portion, I am eligible to seek general transfer.
Where? Bottom portion, page 39, yes.
Bottom.
Yes.
The last,
General transfer on special ground, yes. Stroke.
transfer on special ground. The transfer rules amended notification made there under the following reasons. It is not the transfer of special ground.
No. Subject is prayer. At the middle, subject prayer for general transfer.
Yes.
It is to be treated as a prayer for general transfer.
Yes.
not
So you decide the issue.
Then next.
You decide the issue in accordance with law. Who will take this as secretary or president? You decide the issue in accordance with law. In inter-district transfer, is there any prescribed pro forma?
No.
I am not found.
No. There is no.
Then Mr. Lydius made correct submission.
in the secondary, my lord, there.
But Mr. Ghosh Chaudhary last occasion submitted that for inter-district transfer there is a
There are
in certain districts.
DPUs that too they do not follow sacrosanct.
So it differs from district to district.
Yes, it is within their domain. Which application?
Inter-district transfer. There is a pro forma.
There is nothing to attach to the rule. There is nothing attached to the rule. Maybe and that is known to us.
So is a pro forma is there?
No, there is no pro forma.
Show me that.
No, I am telling your lordship. These are all
pro forma. Then petitioner goes.
No, there are self-made pro formas. There are self-made pro formas.
But the board is saying that there is no pro forma. Yes.
Why do you have to say all these things?
Yes.
These are talked about the district transfer, not
Yes.
board transfer.
It is through inspector of schools.
Then DPSC, then board.
Then if it is inter, it is board. That is the procedure meant. Even suppose your lordship today there is no offline, but it has to be from through sub-inspector, then DPSC.
Manually.
Because otherwise all the data is lying with the SI of schools, sub-inspector of schools. Board not having.
No, that is a separate thing. But whether there is any pro forma or not.
But this is the procedure, not.
But no pro forma. It need not be. Yes, sure.
But
affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to transfer of the petitioner from one district to another. Stop. An offline application was made before the concerned respondent authority on 28 February 2025, seeking transfer on the ground of distance in between the present school of the petitioner and
your lordship, 40 page 40, your lordship.
Yes, general transfer any ground I can take.
That I am surplus teacher.
Yes, surplus is necessary. As per Rule 4.
He is not surplus teacher.
That will decide. I am surplus.
70:3.
No, 55.
It is here.
So apart from distance, there is a ground of surplus teacher.
But my lord, surplus, he is not surplus.
Very well, that will be decided.
Yes.
If it is surplus, then first it has to be decided by the council.
Board decides.
Surplus.
Report it to
Now, seeking transfer on general ground. Seeking transfer on general ground. Stop. Respondents are seeking transfer on general ground. Stop. Grievance of the petitioner is in spite of preferring transfer application in the month of February 2025 till date, same has not been decided by the concerned respondent authority. Next paragraph. Respondents are represented by learned advocates, and it is submitted that due to suspension of portal, decision as yet not taken. Next paragraph. Since it is an inter-district transfer from one primary school of Paschim Medinipur to another primary school in Purbo Medinipur, the transfer application needs to be decided finally by the concerned authority of the West Bengal Board of Primary Education. Next paragraph. The sub-inspector of schools of the concerned circle is directed to forward the transfer application of the petitioner along with necessary endorsements to the District Primary School Council, Paschim Medinipur by fortnight from date stop. On receipt of transfer application, Chairman, District Primary School Council, Paschim Medinipur shall process the same and forward it to the Secretary, West Bengal Board of Primary Education by 3 weeks thereafter. Next paragraph. On receipt of transfer application, Secretary, West Bengal Board of Primary Education shall decide the same in accordance with law by 4 weeks thereafter. Stop. The decision to be taken by the Chairman, decision to be taken by the Secretary, West Bengal Board of Primary Education, West Bengal Board of Primary Education shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner. Writ petition stands disposed of, urgent xerox submit. Next.
Grateful, your lord. Extremely grateful.
রাখো তো লাভ নেই, আমার নিয়ে হয়ে গেলে চলে গেলে পাঠিয়ে দিচ্ছে আমার।
Yes, item number 34.
My lord, in item 34, my lord, Dr. Mukherjee is appearing for the state, my lord. She could not come to court due to her illness. My lord. I'm praying for not today.
Well, not this week, Monday.
Okay.
Item number 35.
Victory appearance of the state respondents.
At the time of call, who is for the petitioner? Anybody for the petitioner? At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondents are represented by learned advocates. Writ petition stands dismissed for default. Parties to act on the server copy.
Item number 36.
But I am appearing on behalf of the state.
Transfer on. Yeah, transfer on surplus.
Intra or inter-district? Inter-district. Yes. Where is the transfer application?
My application is page 20.
Page?
20.
20.
Not this week,
13th March, you have made an application. And when you have filed the writ petition? On 4th April. Not even given 1 month time. See the situation. 13 March application, 4th April, writ petition has been, 4th April 2025, writ petition has been filed. At least give some time, reasonable time.
Consider my application.
Who is for the board?
It is in
Intra-district.
yes.
Commission?
My lord, I am for the
Malda.
APSC Mal.
Malda.
Yes.
Very well, you take decision.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Matter relates to transfer of the petitioner being a primary teacher working in a school in Malda. Stop. An offline application was made on 13 March 2025 addressed to the chairman, District Primary School Council, Malda, being respondent number 6, seeking transfer on general ground. Stop. It is submitted that till date transfer application is not decided finally. Next paragraph. Respondents are represented by learned advocates who have submitted due to suspension of portal. Decision could not be taken on transfer application of the petitioner. Next paragraph. Sub-Inspector of Concerned Circle is directed to forward the transfer application of the petitioner with necessary endorsements to the to respondent number 6 by 3 weeks from the date of communication of this order. Stop.
Malad,
On
only
receipt or
only one thing, Malad, it was directly made to the chairman. Whether in the SI office they have given any application or not.
yes, right. It is addressed to the chairman. Where is the application to the sub-inspector of schools?
Only chairman give liberty so that I can application.
Withdraw the writ petition, file afresh after giving some time. Because it is routed through the circle inspector to the DPSC. Otherwise, how the circle inspector will take steps by making necessary endorsements, as Mr. Vishwas has submitted all data is available to the circle inspector. He has to make the necessary endorsements and forward it to the commission, district primary school council. So have you made any application to the circle inspector?
No.
Only chairman.
Then
Liberty so that I can file a
fresh writ petition after giving breathing time to the authorities. Issue. During course of hearing, learned advocate representing the petitioner submits. Learned advocate for the during course of hearing, learned advocate for the petitioner prays for leave to file, prays for leave to withdraw the writ petition with liberty to file afresh. Stop. Respondents are represented by learned advocates. Next paragraph. Considering the efforts of submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh with better particulars on the self-same cause of action. Parties to act on the server copy of the order. Next. Record an order. 35 to change করে দাও, dismiss for default দরকার নেই. At the time, accommodation is paid for on behalf of the petitioner at the time of call. Stop. List the matter under the heading motion in the monthly combined list of May 2025. Next.
নামটা দি item number 37.
37, my lord, I am for the petitioner.
My lord, I am for the state.
My lord, this is my affidavit of service and deficit court fees. The petitioner participated in teacher eligibility test 2022 conducted by the West Bengal Board of Primary Education, my lord. The notification is of 29th of September 2022. My lord, teacher eligibility test held in the month of December 2022, my lord. After the examination, my lord, all the applicants, all the participants were handed over with their carbon copy of the OMR sheets. After the examination, my lord, in the month of January 2023, provisional answer key was published by the West Bengal Board of Primary Education. Thereafter, in the month of February 2023, final answer key was published. Subsequently, my lord, in the same month, my lord, that is the month of February 2023.
This for the state.
My lord, I am for the state. Read by Mr.
Board. DPSC is not.
No, my lord, this board is the answering respondent, my lord. My lord, what happened, my lord? After the result of the TET, my lord, several writ petitions are filed before this Honorable High Court, stating that in respect of 23 questions, my lord, answer option chosen by the West Bengal Board of Primary Education is wrong or erroneous. To some extent, my lord, in respect of some questions, my lord, more than one answer option can be correct, my lord. My lord, matter went before the before Honorable Justice Rajasekhar Mantha. His lordship was pleased to pass an order dated 25th of April 2024, directing a committee to be formulated by the Vice Chancellor of Jadavpur University and directed the petitioners as well as the West Bengal Board of Primary Education to submit their reference before the Vice Chancellor of Jadavpur University. Well, the said order was challenged by the West Bengal Board of Primary Education before the Honorable Division Bench. Well, Division Bench, by its order dated 23rd August 2024, held that the order of Honorable Single Bench was set aside and Division Bench was pleased to formulate a committee consisting of 3 persons. One is from West Bengal Board of Primary Education itself, One is
Division bench.
yes, my lord. Division bench presided by my lord Justice Tandon, my lord. Directed the board to formulate a committee consisting one person from them, one person from Vishwabharati University, and one person from Calcutta University having expertise in the subject concerned, my lord. My lord, division bench was well aware that since there are several questions, 23 questions are there, my lord, more than one committees are possibly there will be opportunity to formulate more than one committee since the questions are divided in 5 categories, 5 subjects. My lord, this order was passed by Honorable Division Bench on 23rd of August 2024, my lord. The committee was formed. The committee was Division Bench in its order dated 23rd of August, my lord, did not specify any time period to conclude the work and to submit the report.
Order of the division bench was on 23rd of August
2024, my lord. But there was no time specification by the Honorable Division Bench. It was left open for the Honorable Single Bench to decide and to take the report from the committee as expeditiously as possible, my lord. My lord, now thereafter, my lord, the committee is yet to file its report, my lord. My lord, few days back, it was submitted on behalf of the West Bengal Board of Primary Education that the committee has done his work in respect of most of the questions, but in respect of some questions, they are yet to create their opinion with regard to the final answer option. So they prayed before the single bench for allowing them some more experts in their committee. But since it was the order of the division bench, the single bench initially did not interfere. So West Bengal Board of Primary Education has filed an application. What I believe, madam, they have filed an application in a dispose of appeal and praying addition of member in the committee. This is the present situation, my lord. Hundreds of writ petition is pending on this subject, my lord, and after publication of the result of TET 2022, my lord, they are yet to come with the recruitment notification also.
Selection process is of 2022.
This is my lord TET, my lord, 2022.
Oh, this is TET 2022. Primary TET 2022. Now you want, you are praying for publication of report by the committee, which was constituted in terms of the order of the Honorable Division Bench.
My lord, I am praying. Petitioners herein before are praying marks for the those disputed questions subject to the.
But unless and until
yes,
that issue is decided by the Honorable Division Bench in connection with the application, which has been preferred by the board,
yes, ma'am,
for inclusion of other members in the committee, in order to expedite the process of evaluation of the correctness of the answer key. How this issue can be gone into at present by
that's true, my lord. I'm only on that point, my lord. Since they have submitted that in respect of some questions, they have, though it was not submitted by an affidavit, but it was submitted verbally that in respect of some questions, they have attained their opinion. But in respect of some other questions, my lord, they are yet to reach the finality. So, my lord, may I pray for submission of the report in respect of those questions only?
No, that will create a difficulty.
Well, only one thing, my lord, your lordship will kindly.
And that is not the purport of the order of the Honorable Division Bench as you are submitting.
Yes, my lord, that's true, but the order of the division bench.
A composite report has to be filed by the committee.
Absolutely, my lord.
Now the issue is pending hinges upon the fate of the application filed by the board before the division bench.
Yes.
Now, how at this stage single bench can interfere with the issue?
Only one thing, my lord, if your lordship was pleased to direct the board to file the report which they have formed. My lord, your lordship kindly visualize the situation, my lord. August 2024,
the order of the Honorable Division Bench.
Yes, my lord, I have annexed, my lord.
And your can.
My lord, order of the division bench,
which you have filed before the division bench, my lord, for modification of the order of the division bench.
My lord, can, my lord, immediately. My lord, date was fixed, my lord, in the month of, my lord, April, in the, my lord, before the, my lord, earlier bench. My lord, as soon as it was detected that 1 or 2 experts is more required, but in the month of February, March, my lord, we pointed out the immediately, before listing the matter, we pointed out before the single bench, the earlier, my lord, determination. My lord, the bench said, my lord, you mention the matter, list the matter. The matter was listed, my lord, you mentioned. Then the
mentioned before which court?
My lord, the single bench, because all the matters were coming before the single bench. my lord, we said that your lordship can also do it because your lordship ultimately, after the order of the division bench, your lordship has modified the order, not modified, my lord, the modalities was also, my lord, fixed by the, my lord, the timeline and, my lord, other. So your lordship can also do. My lord, they opposed that your lordship cannot do. It is by the division bench.
No, 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 we did not oppose. Well, I'm
I believe
opposing.
when my learned friend, my lord, says I did not, my lord.
Why should I oppose? It is our fate.
Yes.
My lord, thereafter, the learned single bench, my lord, held that no, it should not done by this bench because the order ultimately passed by the division bench. You go before the division bench. Immediately, my lord, we file the application for clarification.
That application is pending.
My lord,
Already
they first
Give me the can number.
My lord, I'm just giving you the can number.
Yes, that is what
in the list also. It is
Yes.
the bench was constituted because the other judges, my lord, still, my lord, is available. So bench, we prayed the, my lord, before the Chief Justice.
Please give me the can number.
I'm just giving you the last.
initially they mentioned the division bench did not interfere, stated that
And the copy of the division bench order.
My copy of the division bench, page 111. My lord, your lordship, it is just the matter. The facing page, your lordship. This is the only matter because of our, my lord, instance, my lord, it has come to the list. We are not delaying the matter, my lord. We are also trying to, my lord, dispose of immediately so that, my lord, all the, my lord, issues can be resolved.
Issue.
As and when, my lord, the bench will sit, my lord,
Petitioners participated in Teacher Eligibility Test 2022 and result was published.
yes,
And subsequently result was published. Stop. Dispute arose relating to correctness of answer key,
options.
correctness of answer key as a result whereof issue in connection with writ petitions, issue was first considered by the coordinate bench and thereafter issue traveled before the honorable division bench. Stop. The honorable division bench, while deciding the three intra-court appeals, first one being MAT 917 of 2024, within bracket West Bengal Board of Primary Education and others versus Moushona Mitro and others. Directed the authorities to constitute a committee in order to examine the correctness of answer key. Stop. Subsequently, committee was constituted, but while examining the correctness of answer key, West Bengal Board of Primary Education felt necessity of inclusion of
not West Bengal, the committee failed.
Achha, while ki bolam, while answer key, it was felt that other subject experts are required to be included in the committee for submitting a comprehensive report. So, in order to get such permission from the Honorable Division Bench to include some other members in the committee of experts, an application being Can 2020 being Can 24 of 2025 has been taken out by the West Bengal Board of Primary Education, and same is running in the list.
Monthly.
And same is running in the combined monthly list of April 2025 before the Honorable Division Bench. Next paragraph. In view of pendency of the issue before the Honorable Division Bench in connection with an application being Can 24 of 2025, at this stage, issue ought not to be examined by this court. Stop. Let the writ petition go out of list with liberty to mention after the issue is decided by the Honorable Division.
This was also the order of the earlier bench.
আচ্ছা, ওপরে affidavit service filed on behalf of the petitioners is taken on record.
I have paid the deficit court fees.
Yes.
Grateful, man.
Obliged.
Bad luck, my lord. Matter was 6 p.m. The warrant came, my lord, at 1:30. 2 p.m. Number 8 warrant came, my lord. We could not do the matter.
Item number 38.
Virtually the same order will be passed, my lord. Grant of A category, my lord, scale. Petitioners are getting A category scale. Petitioner is praying for A category scale from the date of attainment, which is the last date of examination. Similar matter, my lord, several orders have been passed by the previous coordinate bench. From one of the matters, a intra-court appeal has been preferred, my lord. In that district, my lord, there is an order passed by the Honorable Division Bench. The previous, my lord, coordinate bench was directing the matter to go out of list in view of the pendency of the division bench. That I understand, my lord, that will be the same.
Issue is pending before the
The
division.
division bench, lords.
That from which date A category scale
Yes.
of pays to be
But
granted.
that, lords, another
What are
matter.
the prospective dates on
My lord,
from,
prospective dates will be first is the date
from the
when-
date of acquiring DLED
Yes,
qualification?
yes. Prospective dates would be first from the last date of examination, whether it will be from the last date of examination, whether it will be from the date when the examination results were declared, or whether it will be from the date from when the printouts have been taken of the certificates.
Issuance of date of issuance of certificate.
Date printout, because the circular says that the boards and the authorities are proceeding on the basis from the date of the printout of the result certificate, which in my humble
The
submission is
DLED
not-
certificate.
Yes,
DLED
yes,
certificate, lords.
which in my humble submission
So
is
there
not
are
right.
3 dates.
Yes, first is the last date.
The division bench will consider from which date it is to be.
Kindly seize my lord,
That's
that
the
the division
pending
bench
before
order.
the division bench.
But in the special bench judgment in secondary matters, it is directed that the postgraduate scale of paper or higher scale of pay is to be granted from the date of publication of result.
Date of publication.
That
Date of
will be
publication,
followed.
lords.
That should be followed.
Yes,
Date of
publication.
But here,
publication,
lords, if
not from the, previously it was from the date following the last
date of
date
the
of examination.
printing, date of the
Now
printing.
that has been changed.
Justice
In
Mantha,
Utpal
lordship,
Kanti Karan's case,
yes,
and it has been directed that it should be from the date of
of the
publication. of result.
publication.
But here the circular says from the date of attainment. Now, what is the date of attainment? A person who writes the last examination, whether from that date he attends.
This court should not
Yes,
express its
lordship, that
mind
lord of division
since the
bench.
issue is pending before
Yes,
the
Before the division bench,
I have
lords.
given, my lord, they handed over the division bench order. My lord, in view of this, my lordship passes.
ওই অর্ডারটাই দিয়েছে
affidavit service filed on behalf of the petitioner is taken on record. Mr. Lahiri, learned senior advocate, representing the petitioner, submits that issue involved in this writ petition is determination of date for grant of A category scale of pay in favor of primary teacher on attainment of requisite training qualification. Stop. In the same breath, it has also been submitted that the issue is pending consideration before the Honorable Division Bench in connection with one intra-court appeal being FMA 1029 of 2024 within bracket District Primary School Council, Purbo Medinipur and another versus Prashanto, Dolai and others, close bracket. Next paragraph. Next, since the issue is pending before the Honorable Division Bench, touching upon the issue involved in this writ petition, comma, let the present writ petition go out of list with liberty to mention.
Item number 39.
My lord, I am for the petitioner.
Yes.
My lord, this matter is below 5 years. my lord, petitioner is seeking transfer on my lord child's medical ground. My lord, I am requesting my lord kindly go through my lord only this reason order passed by the board 5 years.
First, go through my order and then come back.
Sir,
Not
5
this
years.
week. Ask Mr. Lahiri. Next, not this week.
It was not uploaded, possibly yesterday I have
uploaded.
uploaded.
Item number 40.
Similar.
Not this week.
41. Item number 41.
41. 41 is on for the petitioner. My lord, I would like to draw your lordship only one attention. My lord, below 5 years. My lord, distance from surplus ground, petitioner is seeking transfer, inter-district transfer. My lord, council has power. My lord, council, my lord, just my lord, for I am requesting your lordship. My lord, rule 4 once, my lord, rule 4 once. My lord.
Is it a transfer on medical ground or special ground or general ground? So what is your case?
My lord, it is, my lord, below, I am point of surplus. I am seeking
Below 5 years case?
Below 5 years. My lord, kindly,
How it is possible?
my lord, kindly go through the rules.
If it is
once.
below 5 years?
My lord, council has the power.
এই দেখি
Council has the power. My lord, they are
প্রাইমারিটা
exercising.
কোথায়?
They are exercising.
প্রাইমারি যেটা?
Hey, you. My lord, kindly go through the
না না এটা নয়।
My lord, this is the,
কেন?
my lord, I am,
rule 4, my lord, kindly see the rule 4 or 22 rule. Rule 4, my lord, 22 rule. Council may on its own motion condition on an application from a teacher transfer approved teacher within its jurisdiction from one primary school to another primary school on condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service both the cases. It has been subsequently it has been amended. My lord, that next part, provided that council may, if it considered necessary for proper utilization of service of primary teacher in the interest of education, transfer and approved teacher.
No, rule 4B.
Yes.
Amended rule 4B.
Amended rule 4B.
Just a minute. Amended rule 4B of first there was a rule of 2002. Now this was amended with a notification dated 13 September 2021.
Yes.
Now rule 4B says that in case of single transfer, confirmed teacher has to complete minimum 5 years of continuous service.
And rule 4B has been substituted by this. But that next part, but I am Mrs. Lordship kindly
Substituted
by new rule, rule 4B. Rule 4B only substituted. Next part, I am drawing your lordship's action rule. Kindly see the rule 2002. Rule 2002, rule 4A and B, and there are another. That part has not substituted. Council has the power and they are exercising that power. Interest of education, council may in its own motion reallocate the teacher from one school.
Yes, rule 4.
Rule 4.
A council may on its own motion or on an application.
An application.
So that council will decide how the court can pass, issue a mandamus.
Issue a mandamus.
That is might be for the interest of education, for public service. Council, it is within a domain of the council.
Domain of the council.
Yes.
An application is made before the council.
Who says has instructed you to make an application being an ineligible candidate?
Ineligible, that should be decided whether eligible or not.
It is the administrative discretion of the council. That discretion has to be exercised judiciously. But who whether the council has instructed you to make an application, then
but council can. That application has been made, and if you but only that consideration. If council is decided yes, then no.
Sure. Where is your application?
My lord, application is, my lord, last page, my lord. My lord, that is in page number 17, 13th of March 2025.
Offline application 13th of March. Writ petition has been filed on 5th April 2025, seeking that relaxation is to be given. when there is a specific statutory provision that more than that within a period of 5 years from the date of appointment, no transfer can be permitted.
Definitely. My lord,
How
it
much
is-
cost is to be imposed?
My lord, they are.
Yes.
My lord, surplus ground is it's not a general transfer. The surplus heading is there. My lord, surplus ground.
Matter relates to transfer of the petitioner. Inter-district transfer. Intra-district transfer. Matter is to transfer of the petitioner from one primary school to another primary school in the same district. However, it is submitted by the learned advocate representing the petitioner that on the date of preferring application for transfer on general ground, petitioner did not complete 5 years of continuous service as confirmed primary teacher. Next paragraph. West Bengal primary education within bracket transfer of teachers including head teacher, close bracket rules 2002 has been amended with a notification dated 13th September 2021 and rule 4B and amended rule 4B of the said notification prescribes that in case of single transfer from one school, in case of single transfer, a confirmed primary teacher has to complete 5 years continuous service. So, therefore, amended rule 4B provides a precondition that in the event of transfer on general ground, applicant teacher needs to complete 5 years of service as a confirmed teacher. Next paragraph. In the present case, admittedly, petitioner has not completed 5 years of service. Next paragraph. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent xerox certificate. Average service to overview. Yes, take it back.
My lord, আমি একটা কথা বলতে চাই। Request.
Next matter.
My lord, একটা request.
It is not a time to mention. Sorry.
Mention না গতকালের অর্ডারের বেসিসে।
It is not a time to mention. You are represented by learned advocate.
Item number 42.
I am for the state.
Interest on gratuity, primary.
List the matter under the heading interest on gratuity in the monthly combined list of May 2025. Next. 42.
Item number 43.
Same order. 43, same order.
44.
তোমরা এগুলো দিয়ে দিচ্ছ কেন? তোমরা তো দেখবে ইন্টারেস্ট অন গ্র্যাচুইটি ম্যাটার থাকলেই কম্বাইন্ড লিস্টে চলে যাবে। লিস্টে ঢুকিয়ে দিচ্ছ কেন? না, প্রাইমারি ম্যাটার সেকেন্ডারিতে যেরকম করছো সেইভাবেই করতে হবে। Yes.
Here the petitioners are wanting their 10% certificate as they are qualified and they are passed and they are trained candidate as well. So they.
But there was within time you had to apply. There is a specific time within which portal was alive. You did not apply in the portal since you have got the job. Now, after a long period of time, you are coming for issuance of TET certificate in apprehension that you may lose job in future if you do not have TET certificate. Yes,
No, my lord, here my.
35 petitioners for court fee দিয়েছে?
Yes, my lord. We are court fee, we are- My lord, but in earlier. similar
What was the order I have passed in that
No, my lord,
same
no,
same issue?
that
Date
was
which date? Date
14.
date 20?
40.
Date 14.
It was state 17. Earlier, my lord, yesterday was 17. Today is 14. My lord, yesterday's information also I have received, my lord. I have taken instruction that your lordship will pass the order, my lord. That instruction.
So far 14 is concerned.
My lord, lordship pass the order, my lord, will issue the state certificate, my lord, provided he has to, my lord, give, my lord, 2-3, my lord, documents that he qualified in the TET, and my lord, subsequently, your lordship pass the order in the division bench, sitting in the division bench, that TET pass certificate, issuance of TET pass certificate, that whenever, my lord, they will pass, my lord, acquire the training qualification, will get the TET pass certificate. Sitting with the Honorable Justice, then your lordship pass the division bench. Your lordship directors will, my lord, it will take some time. Kindly do not frame any time, because earlier
The time is not framed, then the order is
no.
Order
we
cannot
will,
be.
we will issue, because, my lord, I tell you,
Very
lordship,
well. You take instruction and come back that within which period you will be able
my
to.
lord, your lordship, there are so
Or
many.
all petitioners are working as primary teachers.
Here not in 2014, not all, but they passed it. They can apply for the, my lord, because
So what is the procedure?
I tell you,
That
lord,
they have to apply for certificate, or you will, in terms of this order, you will issue it.
no. In terms of your lordship order, we will issue. Individually, you are issuing.
But what are the particulars which are required to be supplied to the
My lord,
board?
TET qualified, initially the TET qualified, my lord, the receipt, my lord, issued by the board in the official website, my lord, that required, and my lord, the acquiring of
Date
the,
qualified?
my lord, my lord, your lordship, my lord, I just showing your lordship in the, my lord, if it is annexed in the, my lord, that the petitioner has qualified the TET, my lord, not annexed. My lord, a document showing that petitioner qualified the TET, which was issued by the board. On that basis, my lord, all the
So will you be
requirements-
able to submit that document that you qualified TET?
But that
Yes, yes.
because
Affidavit
that- your
service filed on behalf of the petitioner is taken on record. File your document in support of putting in deficit court fee. Stop. In addition, there are two documents have been filed on behalf of the petitioners in support of depositing additional court fees, since there are 35 writ petitioners. Next paragraph. Petitioners have common grievance that till date concerned authority of the West Bengal Board of Primary Education has not issued TET certificate in consideration of fact that petitioners qualified TET 14. Petitioners qualified Teacher Eligibility Test 2014. Next paragraph. Mr. Ratul Vishwas, learned advocate representing the board, submits on instruction that if reasonable time is accorded, TET certificate can be issued in favor of the petitioners who qualified TET 2014, provided documents are submitted before the board establishing that petitioners qualified TET 14. Next paragraph. It is submitted by the learned advocate representing the petitioners that petitioners will be able to submit documents in support of their contention that they have qualified or they qualified TET 2014. Next paragraph.
And Kenny.
They have qualified TET 2014 along with teachers training qualification or along with teachers training examination.
But training qualification or training qualification.
Next paragraph. In view of the respective submissions made on behalf of the parties, petitioner shall be at liberty to submit necessary documents in support of their qualification of TET 2014 and training qualification by 4 weeks from the date of communication of the by 4 weeks from date. Stop. If aforesaid documents are submitted before the Secretary, West Bengal Board of Primary Education within the aforesaid time, Secretary shall issue TET certificate to the petitioners by 12 weeks thereafter. Stop. Next paragraph. Writ petition stands disposed of. I think next.
Item number 45.
I am for the petitioner in this matter. This is with regard to the petitioner is a retired primary teacher who has been not getting his retirement benefit. On 31st of January 2024, he has retired. She has retired from the service. No with regard to withholding or
when retired?
31st of January 2024. She retired.
Yes.
The mainly the don't know reason communication was done communicated to the petitioner, but she was informed that
the assistant teacher or head teacher,
primary teacher, primary assistant teacher,
yes.
But initially assistant teacher, thereafter he was retired as head teacher.
Head teacher.
Yes.
So therefore, your grievance is that you are not getting pension.
Pension and retirement benefit also.
State.
DI may be given instruction.
No, what is happened?
DI may be given the direction.
The reason that is been orally communicated to him that she was allotted the wrong space in the year of 1996.
Obtain instruction and submit a report on the next date. Let me see that what are the difficulties. Otherwise, ultimately, even if the court passes an order, the complication will arise.
Yes. That will be
affidavit of service.
I shall file one in course of the day, There was
no.
My learned friend is
not today.
Oh, affidavit of service.
Item number 46.
For the petition, my lord. Right. My petition is a confirmed assistant teacher in a primary school, my lord. He has been working since 13 February to 2017, my lord. Has made an application for transfer of medical account as well as
we have completed 5 years service.
27
8 years. Where is your application?
Page 45. Thereafter, also made an application. Page 46.
So you applied on 2nd December 2021. That is on general ground.
Medical ground, spouse medical.
Spouse medical ground. And when offline application was made? Who is inter-district or inter-district? Intra-district. Which district?
No, I am appearing.
You are appearing for the district school council, state. So then the chairman has to decide it.
Chairman will refer. Actually, when a spouse illness ground, my lord.
Yes.
Who
is to take final decision?
Chairman is the authority.
So then you are saying the chairman will refer it?
opinion of the CMH is required because
Opinion of chairman or CMH?
Chairman will
CMH,
take
who will obtain medical certificate from the CMH? Chairman or circle inspector?
circle inspector is the primary authority. He will forward
Forward
it
to the chairman.
chairman.
Then chairman will
Forward
obtain
it to the CMH for medical opinion along with this document.
affidavit shall
medical
be filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner being a primary teacher made an gynecological disorder. Petitioner being a primary teacher made an application for transfer on Utsosi portal on 2nd December 2021. Since wife of the petitioner is suffering from gynecological disorder. Stop. Stop. In reference to a document at page 45 of the writ petition, it is contended on behalf of the petitioner that in spite of preferring application far back on 2nd December 2021, till date, Sub-Inspector of Schools of the concerned circle has not forwarded the transfer application of the petitioner to the District Primary School Council, Nodia, for taking final decision. Next paragraph. Respondents are represented by learned advocates and it is submitted on behalf of District Primary School Council, Nodia, that if transfer application is forwarded by the circle inspector by the sub-inspector of the concerned circle to the District Primary School Council
offline,
in that event necessary steps shall be taken for taking decision on transfer application of the petition. Next paragraph. Having considered the submissions made on behalf of the parties, writ petitions parties, direction is given upon the circle inspector given upon the sub-inspector of concerned circle to forward the transfer application of the petitioner to the chairman to the chairman District Primary School Council, Nodia being respondent number 4, by fortnight from the date of communication of this order. Stop. On receipt of transfer application, chairman District Primary School Council, on receipt of transfer application, respondent number 4 shall obtain medical report from the concerned Chief Medical Officer of Health / Medical Board by fortnight thereafter on medical examination of the wife of the petitioner. Stop. Concerned CMH / Medical Board is required to opine in the medical medical report that nature of ailment of the wife of the petitioner is such is required to opine considering nature of ailment of the wife of the petitioner, petitioner is nature of ailment of the wife of the petitioner requires constant care and supervision. Requires constant care and supervision. Stop. If medical report justifies transfer of the petitioner, chairman and respondent number 4 shall decide the application for transfer in consideration of the medical report by 4 weeks thereafter. Stop. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. Suspension of portal shall not be a ground to reject the transfer application of the petitioner. Next paragraph. Writ petition stands disposed of urgently.
Only your lordship offline.
offline.
Suspension.
Yes.
Portal is
Nothing is required. Court directed. He will transfer forward it. Call the fixed matter.
Item number 119.
অর্ডারটা অর্ডার তোমাদের কাছে রাখুন Yes.
Clearly admitting that they had a comprehensive policy for compassionate appointments when they had appointed in the
2006. 2006.
99 and 97 and 2006.
And you have also demonstrated before this court in reference to the averments made by the petitioner in connection with, made by the company in connection with the previous writ petition, and also from the counter of the union, that the averments were made to justify such scheme and selection of the petitioners for appointment on compassionate ground.
Two things were very important from the last estimate that I obtained permission from the court. One was there was a comprehensive policy, and number two, there was a scrutiny and selection. It was not an ad hoc environment. Everybody who had applied had been taken. It's not like number one question, observation came from your lordship that there is a difference between the 2006 policy and the 2013 policy in that the word indigence has been used.
Yes.
But indigence is a concept which is able, which can be found out only from the periodic situation of country. No appointment if there is an earning member. That was considered to be a penurious situation.
But the expression got changed by promulgating 2013 scheme. It was in 2006 scheme or in the agreement, it was there that if there is no earning member in the family. Now it was changed to a situation where it is considered the indigence.
Please visualize this from the side. 2006 was a more stringent one. In the sense, it did not use the expression indigence. Anybody, any family who had an earning member would not be considered without any reference to the financial position. Yet specifically indigence is brought in force. Meaning thereby, even if there is an earning member in the family, say who is earning 800, 900 or 1000 rupees per month, that will not exclude the family from being considered if the family continues to be in a penurious situation.
So according to you, 2007 scheme in terms of financial hardship is stricter than 2013 policy. It is your contention. If that be so, if this is accepted, then if an exercise is required to be carried out by the company in order to find out the financial hardship on the anvil of 2013 scheme only to the extent of indigence, where is the difficulty?
So that's what the Honorable Division Bench directed at the interim stage.
Division Bench of Justice Bosak's
No, Justice Shen.
previously.
No, in this stage, before it went for final hearing before Justice Bosak, the Honorable Division Bench presided over by Justice Shen directed this exercise to be made. In fact, the company had constituted a committee for that purpose.
So why this was not done?
But the same procedural stand taken. Earlier it was all fine. Suddenly they say there is no post. This has been done or has got government displeasure. Therefore, my action was bad. I don't know how the respondents can challenge each other's action. But this is really, I should say, that this is misleading and contemptuous on the basis of it. The stand taken by the company. They were on record in justifying their action in the previous round. misleading statements.
Yes. Because what is important, especially also in Canara Bank and Ajit versus Ajit Kumar's judgment, that there is necessity to determine the financial hardship.
That's the primary condition in every compulsory appointment.
Yes.
However, at one point of time, when the panel was chosen in 2006, this exercise was done. This honorable court felt that since a substantial period of time has lapsed, why don't you carry out this exercise once again? Because it's after all a question of financial condition. In fact, two of the members of the union had withdrawn. One is doing 30,000 rupees per month by reason of his own business, so he has withdrawn. Which is less than the rate for employees wages even in GRS, but he has very bona fide withdrawn. I don't want to pursue this case.
Out of the 49 petitioners?
Out of 51.
51, now 49 are there.
This door-to-door exercise undertaken, panel chosen on a scrutiny. Please recollect the words from high-sounding designated persons of a public undertaking. GM, HR, Deputy General Manager, they are all filing those affidavits, justifying their stand. Scrutiny, selection. What does this mean? And in the anvil of a comprehensive scheme, they exist. Now that this is thus far the stand of the. Now that they have come up with a story that there is no post, if there was a ban, I have shown to Lordship the ban on recruitment would not apply to compulsory appointment cases. One member, if there is an earning member in the family, no consideration, financial periodic. The 2013 policy at all can be made applicable. This can only be construed in favor of the employees. Please read this holistically. Please take these two things side by side. But I have submitted on the last question that 2013 cannot be a comprehensive policy for appointment because it lacks the basic and essential parameters.
It is not an independent scheme. It is dependent on 2006 scheme. So therefore, at best, it can be termed as a supplementary scheme to 2006 parent scheme. Read with 1997 scheme. Please indicate your from the very beginning referring to 1997 scheme where I will find that scheme. 1997. Just a minute. Page
79 of this.
SLP. এই দেখি SLP copy. এই
Probably in my list of dates, it has normally gone down as 11/1/1999, it should be 1997.
This annexure P1, page 79. Just a minute. Please place the salient features of 19.
The conditions stated down to that page. These are the conditions at page 79. Only dependent son, daughter, or widow will be provided for such compulsory employment. Such employment will be provided to only one member per family. Maximum age shall not exceed 30 years for son and daughter and 40 years for widow of the deceased operative. Qualification should have minimum class 8. Financial condition, such employment will be provided only if there is no earning member in the family of the deceased to support the family. Same.
As it is in 2006 scheme.
without the parameter being laid down. But if this can be constituted strictly, then even if I earn 900 rupees per month, my family will not be considered.
Yes, if earning is not defined elaborately.
Yes. But what does 2013 say? Indigence of the family. One earning 900, one earning 500, that will not prevent the family from being considered.
What should be the parameter of indigence has a broader connotation? What should be the parameter of indigence that needs to be stated in the scheme itself? Otherwise, it is left to the discretion of the authority.
The second Canada Bank Judgment in 2025 says only hand to mouth is compulsory. What is hand to mouth? What is hand to mouth? What is basic standard of livelihood? Did the Honorable Supreme Court consider all these things? But what is basic standard of livelihood was encompassed in 1960 in the similar conference when the minimum wage was promulgated. It's an eight element basket theory. Food, house rent allowance, transport, fuel, children's education, 20 years of clothes for a family of 4 in a year, entertainment, intoxication, toiletries. 9 ingredients that were put in a basket. The 1960 valuation was taken to the basic index.
There is a parameter for teachers are concerned that the first basic pay, first pay of a group D student. If it is less than that, there is a rationale behind this. But while in 2013 scheme, it is not stipulated that what is indigence.
But in fact, for the government of West Bengal employees, the last clarificated order says if the income falls below 90% of the last grant, then one is entitled to that.
Nothing of this sort is there in this 2013 scheme.
It might be taking into consideration the terminal benefits as well, but then it has to be a trend. So please come to the judgment statement.
Yes.
Where the Honorable Supreme Court while demanding the matter has to be considered the roster of the court.
Yes, that was the basic.
Yes.
It was not a judgment under clause 15 of latest patent.
The division means the basic. Please come to the Honorable Supreme Court judgment. The basic reason was the roster was not assigned to that. Irrespective of classification of cases, that was not. So please come to the compilation of that.
We need not go into these niceties of that. So therefore, the issue is wide open. So you argue your case accordingly.
Now, just to show that what is indigence.
Yes.
I have handed up the compilation of that.
Yes, yes, compilation is there.
Please come to page 130. And in our country, there is fortunately a law called minimum wage act 1948. Also suffering from colonial hangover, but still our so that has said what can be a minimum rate of wages for their substance. Please come to page 146.
Page
146. Page 142.
Paragraph
9.
Yes, paragraph 9, 142.
We have earlier noticed the circumstances under which the Act came to be enacted, the Act meaning the Minimum Wage Act. Its main object is to prevent sweated labor and as well as exploitation of unorganized labor.
It proceeds on the basis that it is the duty of the state to see that at least minimum wages are paid to the employees irrespective of the capacity of the industry, or you need to pay the same. The mandate of Article 43 of the Constitution is that the state should endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise, work a living wage, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. The fixing of minimum wages is just the first step in that direction. In course of time, the state has to take any more steps to implement that mandate. As seen earlier, that resolutions of the Geneva Convention of 1928, which had been accepted by this country, called upon the covenanting states to fix minimum wages for the employees in employments where the labor is unorganized or where the wages paid are low. Minimum wages does not mean wage just sufficient for bare sustenance. At present, the concept of a minimum wage is a wage which is somewhat intermediate to a wage which is just sufficient for bare sustenance and a fair wage. That concept includes not only the wage sufficient to meet the bare sustenance of an employee and his family, it also includes expenses necessary for his other primary needs, such as medical expenses, expenses to meet some education for his children, and in some cases transport charge, etc. See Unichei versus State of Kerala. The concept of minimum wage is likely to undergo a change with the growth of our economy and with the change in the standard of living. It is not a static concept. Its concomitants must necessarily increase with the progress of the society. It is likely to differ from place to place and from industry. So when the expression quote unquote hand to mouth in the context of second Canada Bank is to be considered, your lordship can keep this in mind.
Just two. His judgment starts from page 142. Yes.
Now please come to page 157. The second judgment begins at 150.
Page
157.
What is the citation?
Quoted at 1992 1 SCC 290. But at the top sheet it is there. I have indexed it. Please come to second page of the index. With the broad
Financial condition.
serial number 15.
15. It's 150. That's yes, 150. It is on what proposition? Yes.
Concept of minimum the concept of minimum wage is no longer the same as it was in 1936. Even 1957 is way behind. A worker's wage is no longer a contract between an employer and an employee. There is the force of collective bargaining under the labor laws. Each category of the wage structure has to be tested at the anvil of social justice, which is the life fiber of our society today. Keeping in view the socio-economic aspects of the wage structure here of the view, that it is necessary to add the following additional component as a guide for fixing the minimum wage in the industry. Children's education, medical requirement, minimum recreation including festivals or ceremonies, and provision for old age marriages, etc. should further constitute 25% of the total minimum wage. The wage structure, which approximately answers the above 6 components, is nothing more than a minimum wage at subsistence.
Yes.
This concept has been receiving flowering at every phases of judicial pronouncement or with the changing needs of the society as well as with the upliftment of the economic condition.
Because the concept of sustenance cannot be a static concept.
Of course, 10 rupees in 1960 can't be 10 rupees.
With the inflation, it has to be redefined.
That's why every 6 months there is a notification for this enhancement of DA.
Yes.
The state has every state and the central government has a very
Because the price index ratio gets changed.
difference in winter because the cost of insurance is less. Increases during the monsoon. In Bihar, ragi is more used for consumption than in Bengal. But this is a very complicated process.
Yes, yes.
For the purpose of fleet assessment, the company had in fact in 2014 constituted a committee for this purpose. But this was fortunately disclosed by the company in the compilation file before the honorable division meeting. This is not part of records. So the meeting held in 2014, 31st July 2014. Page 196 of the company's most recent file.
31st
July 2014.
In the compilation, it is there.
It's side with the definition. That should be the
That is in the paper. That is in the.
like this. On side with the documents by the company. But we shall get copy for examiner. I just read it. Minutes of the 319th meeting of the Board of Directors held at 14:30 hours on Thursday, the 31st July 2014 at so place. 119. But it goes on to describe the facts of the case in itself. The issue was discussed in GRSC board meeting on 2nd January 2014 and 29 January 2014. After deliberation, the board in principle agreed to recommend to MOD for one-time exception to the existing 5% rule of compassionate employment to consider recruitment of remaining 109 dependent of GRSC employees from the frozen list of 31st March 2006 as a special case for consideration of MOD after submission of authenticated list of 279 candidates to board, clearly indicating 170 already appointed candidates. The board directed that all other terms of the rules of compulsory appointment for dependent of jail employees followed at the time of processing of 109 DIH cases, and there should not be any compromise with the eligibility criteria as per compulsory appointment policy of the company. In compliance with the board directives, available all records have been examined. Following discrepancies are observed. Signed approved list of candidates prior to 31/3/2006 is not available. However, an unsigned list of 279 DIH cases exists. There are 194 entries in the registers maintained for DIH cases prior to 31/3/2006, which are not figuring in the available frozen list of 279. Out of the above list of 279 DIH cases, 235 are recorded in the DIH registers. Remaining 44 cases are not from DIH register. Out of 44 cases, 24 already employed. Financial condition of the family and whether there is any other earning member in the family, which is the primary requirement for compulsory employment, has not been verified. There are 189 entries of applications in the DIH register after 31/3/2006 that we are not confirmed with after 31st March. On the issues pertaining to compulsory appointment of DIH category and charter of demands for wage division, the GRC Limited Workers Union has started agitation in the form of relay hunger strike, shouting slogans and demonstration in the factory premises from 8th July onwards, which is still continuing. Notices and appeals have been made, but I speak for that. The matter was deliberated. During deliberation, so and so JSNS stated that MOD may be requested for one-time dispensation. That was the joint secretary. He himself was a member of the board.
That a relaxation of 5%.
One-time dispensation to the existing 5% rule of compulsory appointment for the appointment of remaining DIH candidates with the recommendation of board of directors. He further stated that the list be scrutinized further. So once it was scrutinized, further scrutinization. And only the genuine candidates be considered in accordance with law and the DIH policy of the company. He mentioned that the genuineness of the candidates may be investigated by CBO GRS. However, board may take its decision in this regard. The board deliberated on the matter and decided to form a working level committee consisting of members from the management and trade unions having minimum 20% membership to scrutinize applications and submit its report to the board for consideration. July 2014.
This 5% requirement was introduced in 2013.
Not this process of after scrutinization, the constitution of a committee with representatives from both sides was conceptualized in 2020. And at the board level, it's already at page 41 of the second.
This ministry 31st July 2014.
31st.
Page. Volume 2. Volume 2.
Volume 1 is okay.
Volume 1 it must be. Volume 2 starts from
আমরা সাপ্লাই রুল আপনারা চেঞ্জ করেছে 400 পরে ভলিউম 2 শুরু হচ্ছে
page 241.
Please come to page 2.
Yes.
Appears for paragraph 41 up to paragraph 40.
Yes.
But just to show that honorable division bench was also considered in this, please come to page 617 of the essay. In 2024, that order of 25th of June 2020.
6.
Page 617. But it's at page 5 of my list of dates.
देखिए सेकंड पार्ट दाओ तो इसे
Page 5 of my list of dates, every practice.
17.
17.
Place exercise for determination of hardship. Yes. Division bench order.
But the board decided that there should be 24, there should be representative from the union. Please come to page 618. Hand of conference of the order and officer certainly creates another group.
বোর্ডে অ্যাপ্রুভাল না হলে করতে দিতে হবে ওই যে স্যার ডিভিশন বেঞ্চের অর্ডারের ভিত্তিতে আমার কমপ্লিট
Open station में भेजें
Now, what is the order date? 14 May 2024.
That's page 9 of my ID. That's in application before that.
এটাকে চেঞ্জ করে নেক্সট
After page 615 of this.
Six one
out of this. No, page 9 of the ID. Page 9 of the ID. Page 9 of the ID.
ইউনিয়ন সাইজ
দেখো তো আই এটা আমরা দিয়েছিল আগের দিন দেখিয়েছিল কাউন্টার না একটা সেট অফ ডকুমেন্টস দেখিয়েছিল Is it in the form of paper book, IA? Additional documents by GRS.
additional documents by union
Additional documents by union.
তোদের আইডি তো আছে
Yes,
এটা আমার পড়ে গেল
file আছে
Yes, page.
Page 9 of my entry 37 of the register.
Yes, fine.
Please figure out paragraph. The respondent shall, in the meantime, ascertain the financial condition of the applicants following the decision taken earlier in this regard.
Now, finally, no exercise was done to find out the financial hardship.
We sent the applicants.
A committee was constituted, as you have pointed out from the another document.
617.
Yes.
Committee was to be constituted with representation and union who has a minimum of 20% representation in the work.
Yes.
So that the identification can be genuine. As following the decision taken earlier in this regard, who prompted this officer to make a new committee for overreaching the board's decision? A new committee is set up. Still we send the papers.
But identification was not made.
We are open to this scrutinization in terms of the 2014 resolution happening at page 617.
Yes.
The company has possibly not left any stone unturned. Do not waylay or not take different stands wherever possible. But if they had not understood the order of the Honorable Division bench, they could have said, which earlier decision do you mean to say? Constituting a new committee, thereafter by board decision.
So according to this new committee, company cannot constitute.
The board had decided in 2014.
That minutes which you have referred to.
That's the minutes of the board meeting.
So only the committee which was constituted in terms of this board, this.
Constitute the committee in terms of the resolution. If there are two trade unions.
Please place that minutes of the meeting again.
Please come to 617.
Second year ago. Yes, 241 SLP. 31st July 2014 meeting.
240. Not at 2,
Show me that minutes only, as per this minutes, only this committee which was constituted can examine the sustenance.
Please come to page 250. 252. 252.
252.
41 and 250. Begins at 241. That's the date of the constitution.
Yes, yes. It starts from 241. So relevant page is 252. Yes. Paragraph 41.
The matter was deliberated during deliberation. Sheet A. K.K. Meena, Joint Secretary in this. Naval Service stated that Ministry of Defence may be requested for one-time dispensation of the existing 5% food of compulsory appointment for the appointment of remaining DIH cases candidates with the recommendation of Board of Directors. He further stated that the list is utilized further and only the genuine candidates be considered in accordance with the law and DIH policy of the company. He mentioned that the genuineness of the candidates will be investigated by CBO GRSC. However, board may take its decision in this regard. The board deliberated on the matter and decided
For a working level committee. They decided to score submit this level committee. Submit with form and working level. The second level. Yes, to form.
Form a working level committee consisting members from management and trade unions having minimum 20% membership to scrutinize applications and submit its report to the board for consideration.
So this committee was considered in terms of paragraph 42. It was constituted.
It was ultimately not constituted. The modality of constitution was decided by the board.
But ultimately, this no committee was constituted in terms of this board meeting dated 31st July 2014. Subsequently, another committee was constituted pursuant to the order of the Honorable Division Bench. That committee did not complete the exercise. Yes.
Please come to the compilation of that.
Yes.
First, I take the judgments which are laid that scheme on the date of consideration shall. The judgments which are in my favor, I shall place. Begin from serial number.
The Canada Bank, Abhishek Kumar and Ashish Awasthi.
These are in my favor.
Yes, that is, these are in your favor.
I shall place the one which are against you at first.
Oh, and the scheme which is prevalent at the time of consideration of the application.
There is a broad caption PC after serial 6 scheme on date of consideration. Whereafter comes 7, 8.
Just, yes, yes. Scheme on the date of consideration, yes. You have referred to judgment 7 and 8. NC Santos and yes.
Your Sampati was please come to page 7.
Page
70.
It has referred the matter to the larger bench.
Please come to paragraph 4. FBI versus Rajkumar is quoted. Is referred to the current conflict.
But is it necessary to go into this reference judgment of Shiv Shankar Tewari in view of paragraph 42 and 47 of Ajit Kumar, where the answer is given by the two-judge bench of the Supreme Court?
Since I shall show that I this cannot apply.
Because already an answer is given. Please come to that judgment of Ajit Kumar.
That is page 1 of my compilation.
Just
On paragraph 24 onwards. It's at page 1 of my compilation.
please just a minute. Yes, yes. First page is not there, but its full judgment is there. Yes. Now come to.
Paragraph 24.
Yes, this is analysis and decision. Just. Paragraph 47. Page 37.
At the same time, we cannot be oblivious of Canara Bank Sutra having been rendered by a coordinate bench. Having disagreed with Canara Bank Sutra, judicial propriety demands that we follow the appropriate course, that is to refer the matter to a larger bench. We are also not oblivious of the legal position that so long the decision that is doubted is overruled, it continues to remain binding. A reference to a larger bench as made by the coordinate bench in Shivashankar, if made by us, would only add to the agony and pain of the respondent, considering that one cannot foresee an imminent resolution of the controversy in light of the admitted fact that the reference is still unanswered.
So therefore, we are also not oblivious of the legal position that so long the decision that is doubted is overruled, it continues to remain binding. So if court goes by this observation, in that event, why NC Santos will not be followed?
Page 83. Please complete.
Because answer already has been clarified.
Please complete.
Thorough examination of all the judgments is not required by virtue of the judgment of Ajit Kumar.
Please come to page 75.
75. Which paragraph you are referring to, Mr. Mojumdar?
Please see paragraph 1.
Paragraph 1.
76.
Yes, the appellants here. Yes, yes, yes.
Rules of 1996 as amended with effect from 1/4/1999. Thereafter referred to as the rules. Those appointments came to be cancelled. What was the discovery that their appointments were made diverge the provisions of the rules as amended. Appointment made diverge the amended rules.
Yes. Just a minute. Wait. Just a minute. The amendments. You are reading from paragraph 2.
The first paragraph. Opening paragraph of the
Evidence.
Deal granted in SAP number 20.
Yes, appointments are made diverge the provisions of Rule 1996.
The amendment to the proviso to Rule 5.
So your contention is this is not an appointment, diverge the rules, because the rule was frozen in terms of 2006. So therefore, it is not squarely coming under the ratio laid down in Santos. Yes, that is.
That's my submission. Number 1. And number 2, once this is accepted in view of the facts of this case, then the 2025 judgment that the rules of the game cannot be changed after the commencement of the procedure.
Tej Prakash. But that is on that issue, they will, I know that they will try to distinguish that Tej Prakash, that it was a case of regular appointment, not a case on date in harness case.
We don't read judgments as statutes or law. A judgment is a statement only of the facts. But NC Santos was deciding an appointment made diverge the amended rules. None of these cases cited at the bar or which the Supreme Court had the occasion to consider was deciding a case of this nature. But the rules of consideration had already started, or the process of recruitment had commenced.
To that extent, this case is unique. That may not be covered by any of the judgments delivered by the Honorable Supreme Court on this issue. Because there is a frozen panel of 170 appointed from the frozen 149.
170 appointed. For the balance 79 process already initiated. Mid-process, objection kept in abeyance. That's the repeated. That's the phrase repeatedly in affidavit. Kept in abeyance. And the application before the honorable division bench is we want to expedite within 6 months and complete the process. Second submission is DOPT rules are not applicable on me. That's the company's stand on affidavit.
That is in connection in 2009 petition.
But even the ministry has clarified. Please see one of the letters written to the union by the DOPT. Page 91 of the counter.
এই দাও তো পেজ 91 কাউন্টার additional document সরাও পেয়ে যাবে rejoined এই যে কাউন্টার কাউন্টার বাই ইউনিয়ন জাস্ট so far according to you Mr. Mojumdar, so far NC Santos is concerned that is distinguishable considering the fact situation of this case. This is your submission. Then you are relying upon Tej Prakash. Have you supplied this in your compilation, Tej Prakash? Just a minute. Which serial number? Yes, 16. But only in case of Tej Prakash, the methodology or the concept of appointment on compassionate ground is completely different. So far, the different from regular appointments.
So NC Santos is the only judgment which has to be followed. Because that was also
If it is stricto sensu followed, that it comes in aid of the company.
Now, but please see, I shall place NC Santos in that. Now, please, I just read page 91 of the counter and just again come back to that.
Yes, yes, yes.
The stand of Union of India.
Page.
Page 91 of the counter.
Yes, page 91.
During this time, the company was dealing with the process. After 2009 introduction, the union had issued the scheme for clarification. This is the
No, from paragraph 4, you have elaborately submitted.
page 91 of the counter. That's the letter written by the Union of India.
Page 91 of the letter.
It's the letter.
But it starts supplementary affidavit on behalf of respondent. Counter by union? No. Counter by union. Page 91. It's not telling. Yes, page 90. It's a letter dated 16th April 2010. Just a minute. Yes.
I'm directed to refer to your letter dated 16th April 2010 on the above subject. The scheme for compassionate appointment issued by this department OM dated 9/10/1998 as amended is applicable to central government employees and is not applicable to an autonomous body. CPSC is an autonomous body governed by its own services.
Scheme of compassionate appointment issued to the department. Scheme of, the scheme for compassionate appointment issued with a department memo number 9th October 1998 as amended, it refers to which amendment? Because it is 2013, not 2006.
No, it refers to not some original scheme which was amended. The sum and substance of this document is government scheme don't apply to this.
Now, is it your case that 2013 scheme is in consonance with the government scheme?
But they wanted to say on a feeling.
It is their stand in the evidence. Yes.
So please come to NC conclusion part of the right. Please come to
Just. Yes.
But I need to place two paragraphs on this.
Indicate those paragraphs and place it.
First paragraph. Please granted that the appellants here were the beneficiaries of compulsory appointments. But on the discovery that their appointments were behold the provisions of the Karnataka Civil Services Appointment on Compulsory Grounds Rules 1996, as amended with effect from 1/4/1999, thereafter referred to as the rules, those appointments came to be cancelled. The amendment to the proviso to Rule 5 stipulated that in case of a minor dependent of the deceased government employee, he or she must apply within 1 year from the date of death of the government servant, and he must have attained the age of 18 years on the day of making the application. Before amendment, the minor dependent was entitled to apply till 1 year of attaining measure. So only a measure can apply, and within 1 year of that. That's the amendment.
Within the 1 year of the date.
That's the amendment. When their services were terminated, the aggrieved appointees approached the Karnataka Administrative Tribunal, but the tribunal found that the appellants were ineligible for appointment under the rules and accordingly dismissed the related applications. Resultant deputations were dismissed by the High Court of Karnataka, leading to present appeals. Please come to paragraph 5.
Yes.
Here is the argument advance for the special. Assigning the adverse decision of the tribunal as affirmed by the High Court, the appellants contend that they have been legitimately appointed on compassionate basis and have rendered service without any blemish, and therefore the authority should not be permitted to apply the amended provisions and cancel the appointment on the ground that the appointees were ineligible to apply for compassionate appointment. Suri, the learned senior counsel, argues that Rule 5 is only procedural and is not mandatory, and therefore compassionate appointment of the dependent children who attain majority beyond 1 year of death of the government employee should not be constituted invalid. Please see what was the argument advanced? On equity. According to the appellants, their cases have to be considered under the unamended rules, which permits the minor dependent to apply for compassionate appointment within 1 year of attaining majority. Describing Rule 9 as a transitional provision, whereunder the period for making application has been changed through various amendments, the counsel for the appellants argued that retrospective application of the amended provisions should not lead to cancellation of the appointment. Moreover, since compassionate appointment was offered without any misrepresentation to the demand. The respondents, on the other hand, argue that the norms applicable at the stage of consideration is relevant, and here, as the appellants had not attained majority within 1 year from the death of the government employee, they were ineligible to seek compassionate appointment under the amended provisions of the compassionate rules. The government counsel contends that since compassionate appointment is an exception to the general rule governing appointment in the service of the state, the same has to be in conformity with the prescribed rules, and those ineligible under the rules cannot ask for continuation of the illegal appointment. The respondents also argue that the government has the power to rectify the mistake and to recall the illegal appointment orders as the appellants were appointed erroneously despite their ineligibility. The essential details of the appellants can be seen in the following chart. But the first column is this is government servant, second is dependent appointee, date of birth, parents' death, minors majority, application. These are the columns. Please see the date of death 25/1/1998.
Yes,
Attaining majority 2000.
beyond 1 year.
Attaining, yes, beyond 1. First, mother applied on 1998. Then, after attaining majority, applicant applied on 2000. So, the application was made after the amendment had been carried out. In that given prospectus, the court was persuaded to hold that the second application filed by the son ought to be governed by the amended rules.
Yes.
Because it was the fresh application which had seen the light of the day after the rules had been amended.
So this was the fact situation where
This was the fact situation of that case. Now please come to paragraph 7.2 at page 79.
7.2. Indicate the paragraph, Mr. I am reading from another judgment where I have read. Please.
Begins with the word pursuant to the order of the tribunal.
After this table.
After the table.
Just two
Just two paragraphs after that.
Yes.
Pursuant to the order of the tribunal, the appellant was reinstated in service on 4/1/2006. Thereafter, an inquiry was initiated against her under Rule 11 of the said rules, alleging misconduct and misrepresentation of her age at the time of submission of her application, seeking appointment on compulsion ground. The appellant was then removed from the service by order of 2006, and when her appeal was rejected by the appellant authority in 2007, she again approached the tribunal. In her OA of 2007, the tribunal, with the order dated 2009, found that there was no misconduct on the part of the appellant. Nevertheless, the tribunal affirmed the cancellation of the appointment with the finding that the appointment was made before the amended rule of 2000, Rule 5 of the amended rules, and thus the cancellation of appointment was found to be justified by the tribunal. The appellant's review petition was also dismissed by the order of 2009. The resultant petition filed by the appellant challenging the cancellation were dismissed by the High Court under the.
Yes.
Now, please skip over to the next paragraph and come to paragraph 8.9, which quotes the rules. Unamended Rule 5.
Yes.
Application for appointment. Every dependent of a deceased government servant, this was the unamended. Of a deceased government servant seeking appointment under these rules shall make an application within 1 year from the date of death of the government servant.
A difference is that 1 year that after the date, a minor could apply, but in the amended rule, that provision was not there. Yes.
The unamended rule allowed the person to attain majority. The amended rule did not apply. It has to be done within 1 year of the death and 1 year of death.
That provision was absent in the amended
And
provision.
the second applicant applied after the amended rules came into force.
That is the crux of the issue.
Now, this is the provision of the unamended, provided that in the case of a minor, application shall be made within a period of 1 year after attaining majority. What was the amendment? Provided that in the case of a minor, 1999 amendment, provided that in the case of a minor, he must make an application within 1 year from the date of death of the servant, and he must have attained the age of 18 years on the date of making the application.
So right of a minor candidate was kept alive, kept open till he or she attains majority. That was the unamended rule. So that was not available in the amended rule.
The amended rule only major could apply and only within 1 year of the death.
Yes. And this application was made by the
In 2000.
in 2000 when the amended rule came into existence.
Now please see paragraph 9. Against classical H. Resurrection water, classical H.
Yes, yes, place it, place it, place it.
Now,
Place it, place it.
it begins with while rule 5, paragraph 9.
Yeah, paragraph 9 on rules, unamended rules, rule 5, and then following 28 May 2002 amended rule 9(3).
While rule 5, there begins with
Yes, yes,
while
yes, yes, yes.
has it enabled a minor dependent to apply within 1 year after attaining majority. The rule-making authority with the amendment effected from 1999 stipulated an outer limit of 1 year from the date of death of the government servant for making application for compulsory appointment. The validity of the amendment rules is not challenged in any of the present proceedings. Following the amendment, the norms clearly suggest that the earlier provision which enabled a minor dependent to apply on attaining majority has been done away with. The object of the amended provision is to ensure that no application is filed beyond 1 year of the date of the government entry. The consequence of prohibiting application by a minor beyond 1 year from the date of death of the parent can only mean that the appellants were undeserving beneficiaries of compassionate appointment as they attained majority well beyond 1 year of the date of their respective. That was the factual matrix, leading to the conclusion that the amended rules will apply.
Yes.
Now please come to the penultimate paragraph of the judgment. But I need not tell you what should be the judgment. Including what the Rajkumar, Canada Bank, what Kumar, these are all quoted. Please take a come to the penultimate paragraph of the judgment. Applying the law governing compulsion.
Yes.
Applying the law governing compulsion appointment called out from the above cited judgments. Our opinion on the point at issue is that opinion expressed on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compulsory appointment. A dependent of a government employee, in the absence of any vested right accruing on the death of the government employee, can only demand consideration of his application. He is, however, entitled to seek consideration in accordance with the rules applicable on the day of death of the government. What was the issue? The rules had already come into force after the.
Thereafter, application for appointment was made by the dependent son of
the
the.
company, I mean, the government was bound to consider the new application in view of the amended rules. Now, please see the second Canada Bank.
Second Canada Bank.
That's actually one of my company. Maybe Russia has already considered.
Yes, yes, just.
But in the right place,
That Ajit Kumar judgment.
the analysis. Right?
Yes, 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 yes.
Page 26, page 26 of.
You place it from your compilation.
Yes. Please come back to the compilation.
Page.
Come to page 26.
Analysis.
We have noticed the core issue arising for decision as well as the guiding legal principles for appointment on compassionate ground herein above. As observed earlier, decision on the core issue would also require us to answer certain sub-issues. We propose to answer them too in the process. The first sub-issue is in relation to context. Supreme Court says don't go into academic issues. The court says go into incidental questions which are sub-issues. But I don't know what is that. Supreme. Paragraph 25. The first sub-issue is in relation to the lapse of time since the respondents.
Yeah, that is a relevant issue. So far, this case is concerned. Lapse of time is not an issue.
This issue has been answered in favor of the inference.
Yes, yes. Paragraph 25, 26 is not required to be placed before this court because I don't think that they are going to take the point of delay.
I'm only indicating what which paragraph deals with what proposition.
No, yes. These paragraph 26, 27, 28 are on all lapse of time.
Yes. Now please come to page 27, just above paragraph 27. Page 27, just above paragraph 27. After that, Beg Raji is mentioned. It would therefore not be prudent or wise to reject a claim only because the time taken by the court to decide the issue is important. So this goes in favor of them.
Yes.
Now,
if the applications are pending before the authority for a indefinite period of time, yes, of that their own fault. Yes, that was the yes.
Now, not this time can be a factor only if the claim is submitted related. That's
Yes.
paragraph 27. But that's in so many schemes of our the board scheme, the school teachers cases. Now, please come to paragraph 20. Age cannot be a bar.
Yes.
Now, please come to paragraph 20.
29.
The second sub-issue relates pertains to the real objective sought to be achieved by offering compassionate appointment. We have noticed the objectives of the scheme of 1993 and construe such objectives as salutary for deciding any claim for compassionate appointment. The underlying idea behind compassionate appointment in death in harmless cases appears to be that the premature and unexpected passing away of the employee who was the only bread earner of for the family leaves the family members in such penurious condition that but for an appointment on compassionate ground they may not survive. There cannot be a straitjacket formula applicable uniformly to all cases of employees dying in harness, which would warrant appointment on compassionate grounds. Each case has its own peculiar features and is required to be dealt with bearing in mind the financial condition of the family. It is only in quote unquote hand-to-mouth cases that a claim for compassionate appointment ought to be considered and granted if at all other conditions are satisfied. Such hand-to-mouth cases would include cases where the family of the deceased is below poverty line and struggling to pay basic expenses such as food, rent, utilities, etc., arising out of lack of any steady source of sustenance. Not the first sentence defeats the second sentence. But one irritates the other according to. But the second sentence means what explains hand to mouth to mean food, rent, utilities, etc. That's what I submitted from 1969 Supreme Court and 1992 Supreme Court.
Yes.
But below poverty line cases don't take into consideration this. But while explaining what is below poverty line, not these have been taken into consideration. This
Yes, yes.
one must have smell of the soil to know what is hand to mouth. This has to be distinguished from a mere foreign standard of life arising out of death of the bread earner. Please, your lordship has seen so many schemes of the government of West Bengal. The latest scheme is if the income falls below 90%. Income from all sources, terminal benefits, pension, etc. If the income of the family falls below 90%, then it's a case.
Yes, yes, next.
Paragraph 31. Thus, examination of the financial condition to ascertain whether the respondent and his mother were left in utter financial distress because of the death of the bread earner is not something that can be easily brushed aside. Then the third sub issue is proper and reasonable assessment. So that's in the facts of the case. Page 30, paragraph 32. The receipt of terminal dues has been considered. The next sub
That the decision of the authority was justified, was found to be justified, while refusing the claim of appointment on company.
One member has descent from the
Yes,
family.
yes.
What would be the interest from the terminal dues? Then paragraph 33 next sub issue is
It was found to be unexceptionable. Yes.
suitability of the claimant for compassionate appointment. Then paragraph 34
Relaxation of age.
It has already been answered in the previous paragraph. Now please come to paragraph 35, the last three lines at page 31.
Yes.
What seems to be logical is that no dependent who otherwise satisfies all criteria for compassionate appointment should be told off at the gate solely on the ground of his law. Then please to paragraph 37. Turning focus to the core issue, we have found that the High Court, both the single bench and the division bench, have heavily relied on decision in Kannada and Supra in reaching their respective conclusions. We do appreciate the predicament of the High Court. Perhaps the said benches were left with no other option but to feel bound by what this court had observed and decided therein, more so because the decision dealt with the scheme of 1993 kept by the applicant itself, which is under consideration here. The High Court, we reiterate, must bear in mind the decision of the that's on the law of precedent. If there is a difference, the earlier law will judgment.
Yes.
paragraph 49 is in terms of article 100. They are giving a policy amount for 5 years.
Article 142 was invoked.
Number, why in the given fact of the case not Abhishek Kumar, the first Canada Bank and of its loss can apply? That's my submission. Please come to page 49. I place the first Canada Bank first. Begin the page 40.
Page. Yes.
40.
Serial number.
Serial number 2.
Yes, Mahesh Kumar. Page 40. Yes.
At 43. The common question of law falling for at 43.
Yes.
The common question of law falling for consideration in these is whether the dependent family members of the deceased employee were entitled to seek compulsory abandonment on the basis of guiding the scheme of 1993. The claim is resisted by the bank on the ground that the financial condition of the family members of the deceased employee is good and that the scheme of 1993 has been replaced with the scheme of 2005, scrapping the provision of.
But Mr. Mojumdar, one thing, in one hand, Canada Bank, Abhishek Kumar and Ashish Awasthi. On the other hand, SBI Rajkumar, MGB Gramin Bank. And then NC Santos, NC Santos three bench judgment is there. Now, ultimately, taking note of this divergent views expressed by the different benches, issue was referred in Shiv Shankar Tewari's case before the larger bench. Now, if that is the situation, then how far this Canada Bank and Mahesh Kumar will come in your aid? Yes, you have distinguished NC Santos. So if NC Santos is distinguished, then independently, since there is no straitjacket formula, even in Ajit Kumar, it has been held that in case-to-case basis, it is to be decided. So therefore, it has to be decided independently. But in deciding this, the present issue, whether it is open to the court to consider NC Santos, to consider Canada Bank versus M. Mahesh Kumar.
Because the other cases which had differed from the first Canada Bank, Abhishek Kumar and Promila, these were all dealing with cases where applications had been made post the change. And these are cases where applications are already on track. In our case, not only were those applications on track, but the phase of recruitment has gone to a large extent.
Yes, already panel was prepared.
So the game has commenced. And therefore I say the special bench judgment will apply.
Special bench judgment means?
Tej Prakash.
Tej Prakash. So the basic difference, as you are demonstrating before this court, that in case of NC Santos, this application was made after promulgation of the new scheme. But in Canada Bank, Mahesh Kumar, then application was made when the old scheme was prevalent, and they
were considered.
Yes. So therefore, the ratio of Canada Bank will apply. So you need not elaborate on this issue. Only you rely upon that Tej Prakash, as you are clamoring from the very beginning.
Please come to page 168.
Yes.
But I need not detail in the document the factual background which prompted the court to consider 180.
Yes, 180,
Basis of the doctrine, paragraph 23.
23, yes.
The doctrine should be prescribed. Change of rules midway through the game or after the game is played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of application of the concept of equality enshrined in Article 14. In other words, Article 14 is the genus, while Article 16 is the species. Article 16 gives effect to the concept of equality in all matters relating to public employment. These two articles strike at arbitrariness in state action and ensure fairness and equality of treatment. They require that state action must be based on valid relevant principles alike to all similarly situated and not to be guided by any extraneous or irrelevant considerations. In all its actions, the state is bound to act fairly in a transparent manner. This is an elementary requirement of the guarantee against arbitrary state action, which Article 14 of the Constitution adopts. A deprivation of the entitlement of private citizens and private business must be proportional to a requirement grounded in public interest. Now, please, statement page 204. But in the same parallel, I have been evaluated.
One batch has got appointment, others are left out. Page 204.
Paragraph 55, conclusions. We therefore answer the reference in the following terms.
Yes.
Recruitment process commences from the issuance of the advertisement, calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the slate list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 and satisfy the test of non-arbitrariness.
Even if the change is permissible. Yes.
So, first of all, the answer is in clear no, you cannot change. What is the writer? It can be changed provided there are extant rules. But this extant rule cannot offend Article 14.
Provided rule is there, or in the advertisement, there is a stipulation to that extent.
First of all, it can't be done. Secondly, it can be done provided there are rules. But these rules cannot offend Article 14.
So, paragraph 23 and 65.2.
These are included in the
Concluded.
given one.
I will hear Mr. Kaur on the next date, and thereafter, if anything is required to be clarified, I will. দেখি পরে কবে একটা date দেয়।
তুই বলেছিলিস 8 ঘন্টা তো চলবে তো আমি হ্যাঁ স্যার দিতে এসে গেছে জানি দেখলাম আমাকে
Mr. Court, on 29th of April, Tuesday.
Kindly give me one.
Yes, yes.
29th is Tuesday. Yes.
Matter is heard in presence of the learned advocates representing the parties. Mr. Somu Mojumdar, learned senior advocate representing the petitioners, has concluded submission. Stop. List the matter for further, list the matter for hearing on 29th April 2025 as 3 p.m. fixed man. Much. For further hearing, গুছিয়ে দিয়ে পাঠিয়ে দেবো।
শুধু ওই 7 point